Good morning, Your Honor. Brent Dinger for the plaintiff.
Good morning, Mr. Ingram. Mr. Elbrist, your name?
Nathan Elbrist.
Nate, you're Nathan Elbrist, though, right?
Yes.
Okay. Did you listen to and understand the rights on the video?
Yes, Your Honor.
Do you wish to speak to a lawyer?
No, Your Honor.
Have you applied or do you intend to apply for funding?
Yes, I do, Your
I
Honor.
already moved you up to the car.
Okay, so you're going to apply?
Yes, I am, Your Honor.
All right. All right, here's what I'm going to do. I'm going to adjourn this 2 weeks.
Okay.
You have to provide us with proof. You have to provide us with proof within 5 days that you've made application for funding, okay? You have to bring it up to the court here. Do you understand that?
Yes, I understand, Your Honor.
All right. Jennifer, give me a date, please.
June 2nd at 9:30.
What day of the week is that? Is that a Monday?
That is a Monday.
All right. All right, so that's what you have to do. So bring that up here within 5 days. Come on back on June 2nd. June 2nd at 9:30, okay?
All right. Thank you, Your Honor.
You're welcome. Good luck.
Yeah.
Granite Televalley versus Jeffrey Paul Campbell, 2501711.
Brent Dinger for the plaintiff.
Mr. Campbell, good morning. Your name?
Jeffrey Campbell?
Sir, did you listen to and understand the rights on the video?
Yes, I have.
Do you wish to speak to a lawyer?
I thought I usually talk to them before I come to you.
No, I'm asking if you want to speak to a lawyer from Lakeshore. Do you want to speak to a lawyer or do you want to proceed on your own?
I'd like to speak to a lawyer.
Do you intend to apply for funding?
No.
We're going to adjourn this 1 week, Jennifer. We're gonna send you the information. It's incumbent upon you to get a hold of Lakeshore, and you should do so right when we get off the phone here. So we're ready to go next week.
I don't need Lakeshore. I thought I was going to talk to the manager, and I usually talk to the manager and lawyer right then and there and make a.
All right. Okay, good enough. So you don't want to speak to an attorney from Lakeshore?
No.
All right. Mr. Ingram, I don't remember if I asked you to state your appearance yet. If I didn't, please state your name and tell me just the total balance here.
Brent Dinger for the plaintiff. It looks like the rent total is $1,660 and 15 cents, Your Honor, inclusive of cost.
Can you pay that, Mr. Campbell?
By the 5th, yes, I'll have it all paid.
On the what?
On the 5th.
All right, here's what I'm going to do. I'm going to let you go into, I'm going to have you wait. I'm going to go through the rest of Mr. Ingram's, and I'm going to let him go into a breakout room and speak with you, okay?
Yeah.
All right, that's what we'll do. So just be patient, and then either way, you're coming back in front of me this morning. Granite Televalley versus Christopher and Roger Cunningham, 2501712.
Brent Dinger for the plaintiff.
Mr. Cunningham, start your video. State your name. You have to unmute.
Guys, it's the first time I've used Zoom, so.
You're doing great. Tell me your name.
Christopher Brian Cunningham.
Where's Roger at?
Roger is my father. He's at his own residence. He's suffering from dementia, so I didn't want to confuse him with anything. I didn't know that I needed to have him attending.
All right, just give me 1 second. I'm sorry about that. I really am.
Oh, not a problem at all, sir.
Did you listen to and understand the rights on the video?
Yes, sir, I did.
You wish to speak to a lawyer?
Whatever legal counsel, I've been here for 21 years. I've never gotten this far, so I'm not sure exactly. The lawyer, is he going to be representing me, or is that a lawyer?
If you want to speak to a lawyer from Lakeshore, I'll be glad to let you do that. That's somebody that the state hires to help tenants out. If you don't, then I'm going to go ahead and proceed.
Yeah, I would like to speak to a lawyer then to find out my options. Yes, sir.
All right, we're going to adjourn this 1 week. Jennifer, give me a date next week.
May 29th at 2 p.m.
May 29th at 2 p.m. Sir, can you, now, do you intend to apply for funding?
Yes, sir, I am as of now, yeah. I haven't received any job opportunities and I've been applying, but
No. I'm asking if you intend to apply for funding with any of the agencies that were mentioned in the video.
yes, I will, sir.
All right, here's what I'm doing. We're not going to give you May 29th. You have 5 days to bring us in proof that you've applied for funding. I'm adjourning this out one more week, which will be what, Jennifer?
June 2nd at 9:30.
June 2nd at 9:30 in the morning. So you have to make application for funding. Within 5 days, you have to provide us with proof that you've made application for funding by bringing it up to the court, okay?
Yes, sir, I can do that without a problem.
And Judge, I do have the representative from Lakeshore here.
Hang on. In the meantime, I'm adjourning it until June 2nd at 9:30. Okay? Okay?
Yep, yes, sir.
Anything else?
Judge, I can put him in with Lakeshore today. They're here.
Oh, good. We'll put you in with Lakeshore today.
Okay, so we can do that over Zoom? I don't have to come down to the court to do that?
Nope, you can do it now. Just bear with us. We'll put you in a breakout room.
Not a problem. Thank you very much, sir.
Thank you. Granite versus Megan Elise Gibson, 2501713.
Brent, take it for the plaintiff.
Where is she at? I don't see
Judge,
her.
I have not had her check in, but I do have an iPhone that just logged in.
The iPhone. You have to identify yourself. What is your name, please?
Jeffrey Molino II.
Okay, you got to take your hat off, please. We'll get to you when we can. Ms. Gibson does not appear to be here, counsel. If you want to take a default, there was a second mailing here, so you're eligible. So go ahead.
We would, Your Honor. It looks like the rent to retain, this is $1,633.16. I have cost of $189.79 for a total of $1,822.95.
And you're asking for a writ date of the
10
29th?
days, so the 29th, Your Honor, yeah.
Tenant failed to appear. The writ date will be May the 29th. Judgment is entered in favor of the plaintiff and against the defendant in the amount of $1,822.95, and that is by default. Granite Televalley versus Jennifer Renee Pauses and Thomas Enzo Blake IV, 2501715. Is Jennifer Pauses here?
Brent, take it for the plaintiff.
Yes, I'm right here.
Where?
Jennifer pauses.
Okay, I'm sorry. Okay, I just got all these pictures here. Where's Thomas Blake?
He's incarcerated at the moment.
Okay. All right. Did you listen to and understand the rights?
Yes.
Do you wish to speak to a lawyer?
No.
Do you wish to speak to an attorney?
No, thank you.
Do you intend to apply for funding?
No, I have the May rent right here, or not May. I have April rent right here, and then I get paid from Social Security on every third Wednesday of the month. So I'll have the rest of it on Wednesday.
What do you want to do, Mr. Ingram?
We can put it over a week and see where she's at, Judge. I'm fine
We'll
with that.
adjourn this to May 29th, Lisa or Jennifer, at what time?
2 o'clock.
At 2 p.m. Okay?
All right,
So
thank
try to get
you.
all your payment in by then he can dismiss it.
Okay, so I'm sorry, what's the date again?
The
29th
date is
at
May
2.
the 29th. May
Okay.
the 29th, 10 days from today at 2 p.m.
Okay, thank you so much.
You're welcome. Good luck. Granite
Thank you.
versus Amber Warren and Blake Warren. File 2501716.
Brent, take it for the plaintiff.
We can say court date that I'm or Good morning. Are you Simon Gobert? And Mr. Gobert, this is your initial appearance in cause number 24, DCCR 0512. Let me pull this up. You're charged with the second-degree felony offense of attempt to commit sexual performance by a child from August 2nd of 2023. Since you've made your bond, have you had an opportunity to try to hire a lawyer?
Yes, ma'am.
Did you hire someone?
No.
Okay, so what I'm going to do, Mr. Gobert, is reset your case for about 30 days to give you some time to see if you can get someone hired. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me back the names of the lawyers you talk to, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? If you'll step in front of the clerk right here, she'll give you that reset notice.
Sign right there under the name.
Jamarcos Zarate Jones. Jamarcos Jones. So the one that says in treatment, did we, you can go.
Thank you, sorry. Yeah, the bond, just
That doesn't mean.
letter and everything,
No response, Your Honor.
This bond will be forfeited for non-appearance and reset at 100,000. Lauren Bridges, you'll call the name Lauren Bridges, please.
Lauren Bridges.
I mean, she went in May 16th. No. She didn't call last week and say, can I?
I just told the bondsman I'll let you know. So I don't know.
No response, Your Honor.
Yeah, I mean, she sent me, she went into rehab Friday. So, her bond will be forfeited for non-appearance and reset at 100,000. And then if she calls her, they can get in touch with her, maybe tell the bondsman if they'll get her here next week, I'll maybe recall it, but she doesn't get to just go. Yeah. But we can let her, call her and get her here. Ronnie Oliphant. Good morning, sir. Are you Ronnie Oliphant? And Mr. Oliphant, looks like this is your initial appearance. Hold on a second. In cause number 25, DCCR 0379, you're charged with a third-degree felony offense of injury to a child, elderly, or disabled individual from February 18th of 2025. And since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Yes, I had one, but released him, but I was trying to see, can I get a lawyer on my own? I had a court-appointed attorney.
Yeah, so that's what I want you to do, is hire your own attorney if you can. So what I'll do is reset your case about 30 days to give you some time to try to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to so I know you're trying, and we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you go back to jail. Do you understand? All right, step in front of the clerk. She'll give you your reset. Lisa Pratt.
Pretty good, thank you.
Good morning, ma'am. Are you Lisa Pratt?
I am.
And Ms. Pratt, this is your initial appearance And cause number 24, DCCR 1460, you're charged with the state jail felony offense of theft with previous convictions, and that's from April 1st of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
They assigned me a lawyer.
They did. So when you're in custody, we give you a court-appointed attorney, but now that you've bonded out, what I do is expect you to at least try to hire your own. So I'm going to reset your case for about 30 days to give you some time to try to hire someone.
Okay.
If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. You need to bring me back the names of the lawyers that you've talked to, so I know you're trying. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order. Do you understand?
I do.
And are you working?
I'm on disability.
You are. If I test you this morning, you can have anything in your system?
I do. No.
Have a seat in the jury box. Let's double check what you got in there. Have a seat in the jury box. Carnell Beard. Good morning, sir. You're Carnell Beard.
Yes, ma'am.
Did you get someone hired?
No. I've spoke with, Kevin Lane, Ms. Holmes, Mr. Smith. What they asking me for down, I barely make that a month. I'll show you my check. I work for
Well,
the city of New Orleans.
Let's do this, Mr. Beard. Thank you for visiting with some attorneys. I'll have you fill out some paperwork this morning to see if you qualify for a court-appointed lawyer. You need to make sure to fill it out accurately and completely because you're going to swear under oath that it's all true and correct, and then I'll take a look at it. Okay? Step in front of the clerk. She'll give you that paperwork. Donnell Coleman. Good morning. Are you Donnell Coleman?
Yes, ma'am.
And Ms. Coleman, this is your initial appearance. And cause number 25, DCCR 0222, you're charged with the state jail felony offense of abandoning or endangering a child with intent to return from January 26th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, I didn't really have the understanding of it.
No, that's okay.
When it
This-
went, so
that-
like when I did call to get in touch with them, they had mentioned they had dropped my case, so I didn't know what that meant.
Well, they didn't drop your case. As far
Rose Rojas, I think.
Yeah, so Mr. Rojas was appointed while you were in custody, and so now that you are, and he's still your attorney unless you hire someone else or we make some other,
So I can't still get in touch with them.
you can get in touch with him, but here's what I expect you to try to hire a lawyer. So you can talk to him about hiring him or anybody else. I'm going to give you about 30 days to try to get someone hired. If you hire someone before the next court date, bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you talk to when you come back, so I know you're trying, and then we'll discuss your options, okay? If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk right here. Yes, ma'am.
I know the stipulations with my case was saying that I couldn't be around my kids. But I mean, I have been going to like parenting classes.
So that's probably one of the, just as big of a reason for you to get a lawyer so we can get your case handled. And if you're doing,
I did parenting classes.
are you doing that through CPS? CPS involved?
At a church, yes, ma'am.
Okay, keep following everything that CPS, whatever their service plan is, keep following that. A condition of your bond is going to be that you not have at least no unsupervised right now. So if they're allowing you contact, it needs to be supervised only, okay?
So if I am able, someone has to be there.
Mhm.
Okay.
Until we say something
I missed my
otherwise.
graduation and everything.
Well, just make sure it's supervised right now and get you a lawyer and we can move your case along and hopefully get you where you need to be with your kiddos, okay? All right, step in front of the clerk. Precious Eaglin. Good morning, ma'am. You're Precious Eaglin. And Ms. Eaglin, you are here on 2 cases, initial appearance and cause number 25 DCCR 0317. You're charged with the 2nd-degree felony offense of assault on a peace officer. And cause number 25 DCCR 0318. You're charged with the 2nd-degree felony offense of aggravated assault with a deadly weapon. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I spoke with Mr. Burbank, but I haven't officially hired him because I was going to talk to somebody else.
Okay.
It's like the amount he wanted as well, so I'm need to call somebody else and see.
Okay, so what I'll do is give you about a 30-day reset to either get Mr. Burbank or someone else hired. If you get someone hired, just bring the reset notice that you get today to that lawyer. They'll tell you what to do.
Yes, ma'am.
If you're unable to hire someone before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me the names of the lawyers that you talk to when you come back so I know you're trying. Then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order and you would go back to jail. Do you understand? All right, step in front of the clerk. She'll give you that reset notice. Shadaman Mitchell. Shadaman Mitchell.
Shadaman Mitchell.
You're pretty.
No response, Your Honor.
Bond will be forfeited for non-appearance and reset at 100,000. Jeremiah Paya or Paia. Good morning, you're Jeremiah Paia?
Yes.
Paia. And Mr. Paia, did you get someone hired?
No, ma'am. I talked to 3 different ones. They all said about the same price to the phone.
Who'd you talk to?
Walker, Mr. Walker from Liberty, someone from Liberty, Mr. Walker from Walker Law Firm, someone from Crenshaw, I forgot their name.
Okay,
And they all said about the same price.
all right. You didn't write those things down for me?
No, ma'am. It was on my phone,
Okay, where's your phone?
in my pocket.
Look it up, let's see.
And then the one from Liberty, they just told me over the phone like 7,500. They
Okay.
didn't tell me their name or nothing. Same for Crenshaw.
What do you mean they didn't tell you their
I was
name?
asking, I was like,
Well, how did you call them? Who'd you
I
call?
called my phone. I just called the law firm.
Right,
And they didn't put me through to nobody. They just said 7,500. But Mr. Walker, I didn't catch his name, but I talked to him for about 40 minutes on the
Okay.
phone.
good.
And he was just telling me everything about like what he would do, this,
Mhm.
over, and what a lawyer would do, and everything all like that.
Are you working?
Yes, ma'am.
Okay. So do you think you're gonna be able to get one of them hired?
Because Mr. Walker, he said he had payments, but he didn't really trust us that much because of people in the past. So
Where are you working?
FedEx.
Okay. So here's what I'm gonna do. I'm gonna reset your case one more time for you to talk to some other attorneys. Because there are some out there that charge different amounts than what you've done. So go talk to at least 3 more. See if you can get someone hired. If you can, great. If not, bring me those names of everybody you've talked to. Then we'll discuss what your options are, okay? You don't have to limit it to just 3.
Yes,
The
ma'am.
point is to hire someone. So call as many as you can, make as many appointments, get, so that you can see if you can get someone hired, okay?
Yes, ma'am.
Step in front of the clerk. Kevin Diaz. Good morning, you're Kevin Diaz. And Mr. Diaz, this is your initial appearance in cause number 25 DCCR 0418. You're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from March 5th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No.
Okay. How old are you?
19.
So what I'm going to do, Mr. Diaz, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer. They'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of who you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand? All right, step in front of the clerk and she'll give you your reset notice. Zachary Turner. Good morning, sir. You're Zachary Turner?
Yes, ma'am.
And Mr. Turner, this is your initial appearance in cause number 24, DCCR 2197. You're charged with the first-degree felony offense of fraudulent use or possession of identifying information, and that is from April 22nd of 2024. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer? Okay. Looks like you also have prior felony convictions, so it's going to be very important that you try to get someone hired. What you're charged with is extremely serious, obviously. So what I'm going to do, Mr. Turner, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer, and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back the names of the lawyers that you've talked to, so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following the court order, and you would go back to jail. Do you understand?
Yes, ma'am.
All right, step in front of the clerk. She'll give you the reset notice. So the next one, Dylan Wilkinson. Dylan Wilkinson. That one has an AFRS. How you doing today, Pickens?
Good.
This bond will be forfeited for non-appearance and reset at 100,000. See, Mr. Jones, come up, sir. All right, you're Jamarcus Jones. It's very important that you're here on time. So I'll recall the bond forfeiture. And Mr. Jones, this is your initial appearance. Give me just a second. So you're on probation for theft of a firearm. I set a bond on that probation, and now that you've made that bond, I expect you to try to hire a lawyer. So what I'm going to do is reset your case for about 30 days, and you need to try to get someone hired before that next court date. If you do, just bring the reset notice that you get today to them. They'll tell you what to do. If you're unable to, then you need to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Make sure you visit with them. Bring me back the names of who you've talked to, and then we'll discuss your options. If you don't do that, then when you come back, I'll raise that bond back up and you'll be back in jail. Do you understand? It's also important you're still on probation. You need to be doing every single thing you're supposed to be on probation right now, because if you don't, that's only going to make things worse. All right? Okay, step in front of the clerk. She'll give you that reset notice.
Thank you.
She's saying she can't go because she's on dialysis and heart valve and stuff, so she can't go to the restaurant.
I know she can eventually.
No, that's what I told her. She said, you're gonna have to do it.
Yeah, it'll be positive if not.
She was.
I know. I feel like there's probably maybe more to it also, just based on. Let's see. So is anybody, are they all going to be here on the Capitol? That's what I thought too. See, is Miss Jordan, Mr. Brewer? Are y'all ready for an announcement?
Yes, Your Honor.
It's, we need Trishad Tarrant, please. Good morning. As state this side, defense this side. Not that it really matters, other than the fact that it keeps it straight in my head. Good morning. How are y'all this morning?
Sure. Good, how are you?
Good.
I saw you went viral about 2
Oh,
months ago.
there's a few of them out there, unfortunately, yeah.
No,
It's
unfortunately, yeah. It was actually very entertaining.
Good morning, sir. You are Trishad Tarrant, and Mr. Tarrant is charged with capital murder of a person in a prison. Mr. Brewer, Ms. Jordan, where are we, and what's the announcement?
Your Honor, the state is announcing ready. We have no pretrial at this time. I believe I have offered a plea offer, a formal plea offer to the defense.
And she has, that offer has been forwarded to my client. So at this time, to say that we will probably set this back to trial. If we could, perhaps February next year, just move on.
Well, it'll be when it'll be. But what I do want you guys to do, if there's a formal offer, I'd like to get a formal rejection of that. I have those forms on the tablets. We can get, maybe Mr. Rojas or Mr. Parker can help you fill out that formal. If you don't want to accept a plea agreement, I'll go through that today. Once we do a rejection, the case is placed on the trial docket. Typically, I don't accept that same plea agreement. You can plea open to the court. It could be something different unless there's new information that either of you get between now and then. So once it goes on the trial docket, it'll be expected to go to trial, or it'll be something different because of some information that you guys received. So I'll hold it. If you want to grab one of those tablets. Mr. Rojas, would you mind helping? Thank you very much, sir. And as soon as you do that, I'll go through all of that, bring you back up, and then we'll get it set for trial and look at kind of everybody's, how long we think that might take, and then we'll schedule it around that. But we're definitely not anywhere close to looking into February. We're looking at this year probably, based on our, unless there's some big reasons, but we'll see where we get, okay?
Okay.
All right, I'll hold it while y'all get that taken care of. Mr. Kimler, you have Tajuan Mack.
Yes, he's on call.
Gotcha.
I think he's on call.
Yeah, there shouldn't be many on. Tajuan Mack.
I went out to the jail last night to see him. He said he was on call.
Okay, but he has done it now.
He's done it since you ordered him to.
Okay.
It's just not been long enough.
No response,
Okay.
Your Honor?
He may be running late, Your Honor. I did go out to the jail last night and they informed me he was on bonds.
Yeah, he's on bond. His bond will be forfeited for non-appearance, reset at 100,000. Obviously, if you get in touch with him and he shows up today, I'll reconsider that. But it is set for trial to begin with jury selection on June 2nd.
I am ready.
Okay.
Your Honor, if he goes into custody, I'll still be able to try it.
All right, I'll number the case. Obviously, if anything changes, you'll let me know.
Yes, Your Honor.
Okay. And then you have Joshua Mays, Mr. Kimler. Joshua Mays.
The owners would have to cover that. Yeah, they're all over. He's speaking to this. He's probably gonna start making rents for the times. That's what I said, orange, in orange,
Good morning, sir. You're Joshua Mays, and Mr. Mays is on probation for burglary of a habitation. Motion to revoke has been filed. What's the announcement?
Your Honor, if the court would entertain going through the motion, we can enter please, and then get an updated pre-sentence.
There's no agreement?
No, Your Honor.
Give me just a second.
Good morning.
Good morning. Mr. Mays, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. And will he waive the formal reading of the motion?
So waived.
Mr. Mays, in cause number 20-36100, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 13th of 2021 for burglary of a habitation, and that was a 3-year deferred probation. Is that correct? I'm assuming that's been extended. Otherwise. So it alleges in that probation, or in that motion, that you violated your conditions of probation. Count 1 alleges that you failed to report to the probation department as required for the months of October and December of 2024 and January of 2025. And is that true or not true? Count 2 alleges that you failed to provide verification of participating in the GED program. Is that true? Just today, it's just true or not true, and then we'll get explanations later. It's not true, okay. Count 3 alleges that you failed to provide verification of entering and successfully completing the moral recognition therapy, that MRT program. Is that true or not true? And count 4 alleges that you're behind in your court assessed fees. As of January 15th of 2025, you were $3,685 behind. Is that true or not true? All right, did you enter your pleas of true to counts 1 and 4 freely and voluntarily? Speak up, please. And did you plead true to those because they're actually true? All right, then I'm going to find that you entered your pleas of true to counts 1 and 4 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case so that we can have a sentencing hearing. I'll get probation to do an updated report. Looks like we probably will only need a probation officer, so we can do that on a normal day.
Yes,
shouldn't take long. All right. And so you need to stop and talk to probation on your way out of the courtroom so that they can make sure and tell you what you need to do to get ready for that sentencing hearing, okay? All right, we'll see you back then.
Mr. Mays.
Oh my gosh, man, I don't know what's happening. Fuck, I need to sneeze. Mr. Pageant, you have Damian Douglas.
I'm doing a dismiss on that right now.
Okay, I'll sign that and he's free to go. Thank you, Mr. Pageant. Mr. Price, you have Dale Johnson, 3 cases. She can have that back. Dale Johnson? Okay.
Cornell Beard.
Morning. Good morning, ma'am. You're Dale Johnson, and Ms. Johnson is charged in 24 DCCR 1570 with indecency with a child by sexual contact in 24 DCCR 1571 and 1572 with aggravated sexual assault of a child. And Mr. Johnson, what is the announcement?
Not ready, Your Honor. Our investigation continues. We have served subpoenas on 2 school districts. We're awaiting those records. I understand we're also awaiting some records from Texas Department of Family and Protective Services.
Okay.
Agreed order, court signed.
Okay, that should be, that was signed back at the end of February, and I see your subpoenas. All right, so let's do this. I'm going to do maybe a 45-day reset instead of a 30. Hopefully we'll get somewhere on all of those documents, the CPS as well as what you've done, and see if we can get an announcement at that next court date. Make sure you stay in touch with Mr. Price. He'll let you know when you need to be back. All right, thank you. Mr. Samuel, you have Tyreek Flanagan?
Yes, Your Honor.
Good morning.
Good morning. How are you?
Doing great. How about you?
It's a great day to be alive.
It is. Every day is, right?
Yes, ma'am.
Good morning. You're Tyreek Flanagan. And this is cause number 23 DCCR 2310. Mr. Flanagan's charged with indecency with a child by sexual contact. What is the announcement?
Your Honor, we've gone back and forth with this quite some time.
We have.
I don't think we have any choice but to set it for trial.
Okay.
There's an issue with the outcry person. There was a CPS case in Harris County that was dismissed because of the source. And we've not been able, we tried to get that information. The state has tried through CPS, but we're not getting it. So we don't have much choice but to set this for trial.
I mean, I'll order it.
Well, that's the thing, Judge, we've done that, and we've reordered it,
I see that. We've done a second.
and what we're still getting back is the same set of records.
But it's not the records that show
With newer-
the dismissals
Right.
and why over in Harris
Do y'all want
County.
to do a very specific, try one more time with
And I talked with Kelly Friday. I was on the phone with Miss Adams, who's the regional attorney.
Right.
About, but we're getting another copy because our copy is gone. However, the newer stuff wouldn't have been in it. This is newer allegations that's happened since I've been on the case.
So are they going to work on getting that?
That's-
Did she say that?
I didn't get a specific, I'm still trying to get the original records. So we've sent this a second amended that I wrote specifically to get newest, and it still didn't come back. So.
Okay,
that was
but you
part of
talked
that.
to her and she knows.
That we're trying to, her assistant is getting me stuff. I'm in contact with her.
Okay,
But the newer stuff is the problem, dude.
right, but I don't want it to be. I'll call her, we'll call her. We've had no issues dealing
Right.
with her if we need something. So if y'all need me to do something, I want to get it done.
We just need to know the basis of the dismissal in Harris County. That's the same culprit. that
Do
we-
a joint email to me today with the two of you guys and me saying what you need. And then I'll forward that and give Stephanie a call and see if we can find out what we need to actually get that specific information.
And I just want to let the court know, like, since I've been dealing with the council on this, I've reached out to the Houston office, CPS, to find out if there's information that is get through that office as opposed to going to Austin.
Right.
The way we go, I've not gotten a response. And
Okay.
I've gotten turnover and all.
Send me something today and then we'll try to, and before we put it on the trial docket, let's do one more reset. Let me reach out to Miss Adams, see if there's something she can do to help us with that Houston information. And then there's got to be a way to get it. So I'll call whoever I need to call.
Thank you.
Okay. Stay in touch with Mr. Samuel. He'll let you know when you need to be back. And then you've got Daisha Mark. It looks like that's set for a plea. Mr. Samuel, you're going to work on that?
Yes, Your Honor.
I'll hold that for you. Mr. West on Ramadan Castillo, 3 cases. Can I get a trial docket?
Yes, we did. Something happened, I don't remember what happened. Yeah, that's right.
I think that's what happened on this.
Yeah.
Yeah. Good morning, you're Ramadan Castillo. And Mr. Castillo is charged in each of his cases with aggravated sexual assault of a child. It's set for trial to begin with jury selection Monday, June 2nd. And what is the announcement? All right, well, obviously, it is one of the older cases. I anticipate it being at the top. We'll find out, I guess, actually next week, because we'll have a docket next Tuesday. But I anticipate it being up there. If anything happens between now and next Tuesday, let me know. There won't be any plea agreements after that. So if anything changes, y'all get together, and otherwise, we'll try to get it taken care of on that day. All right, stay in touch with Mr. West. He'll let you know when you need to be back. Mr. Parker on Benjamin Barker. Good morning. How are you? Good morning, sir. Are you Benjamin Barker? And I'm going to first take judicial notice of the court's file and cause number 24 DCCR 2194. And Mr. Barker was evaluated for competency to stand trial. We received and was found not competent, was sent to the John Dunn Behavioral Science Center for competency restoration, was restored, and I received that packet dated April 1st of 2025 with the finding that Mr. Barker is competent to stand trial. It includes the evaluation report, and that is from Dr. Guzman, as well as the attending physician's report of patient progress. And so is there any other evidence with regard to competency?
None I'm aware of, Judge.
Not from the state, Judge.
Then based on that, at this time, I am going to find Mr. Barker competent to stand trial. He's charged with harassment of a public servant. And what is the announcement?
Your Honor, he informed, I haven't talked to him till today. He just got out of jail. He told me 2 weeks ago. He's had multiple injuries and his foot is broke.
Okay.
And I haven't talked to him. As of now, he wanted to do a rejection, but I thought, being that I hadn't had a chance to talk to him in detail, that it may be worth resetting.
It is. Let's do this. Mr. Barker, I'm going to reset your case about 30 days. You need to make sure and call Mr. Parker, visit with him either in person or on the phone, your attorney, before that next court date, and he can go over everything that he knows about your case, that he's received from Mr. Coleman, what your options are, and then we'll get an announcement at that next court date how you want to proceed, okay?
And I've also indicated to him that he could hire his own lawyer, and because he kind of indicated that may be something he wanted to do.
If you have the funds and you want to, then you need to hire your own attorney for sure. If you're unable to work and you can't afford one, I'm going to leave Mr. Parker on if you can't afford one. But if you can obviously hire your own. If you're not going to do that, you definitely need to call and talk to Mr. Parker about your case. Okay? All right. We'll see you back in about 30 days.
Forfeiture is here. Do you need to back? They already said they're ready. So I don't know. Whatever. Tasia one Mac.
Tajuan Mack. He was upon forfeiture that showed up. Mr. Mack, Mr. Mr. Kimler was here already. We called your name. You need to be here on time, okay? Otherwise, you're going to end up with a bond forfeiture and you'll be put in jail, and you don't want that to happen. So I'm going to recall the bond forfeiture. Your case is set for trial to begin in a couple of weeks. The attorney's announced ready. So I'm going to number the case for trial. You need to stay in touch with your bondsman and Mr. Kimler, and they'll let you know when you need to be back and ready for trial. It'll be in 2 weeks. Okay, you're free to go. Say Rochelle Manuel, Mr. Parker.
She's outside. Michelle Manuel. I don't think Margaret showed up, or he had.
Good morning, you're Rochelle Manuel. Yes, ma'am. And Ms. Manuel's charged with aggravated assault causing serious bodily injury. What is the announcement?
Your Honor, she's been very good about staying in contact with me about updates and all that. We have a new plea offer that Mr. Nichols gave us today. She wants to accept that offer. She told me this 2 weeks ago that she's trying to be responsible. Her apartment lease expires this week and she gets her last check. And she's going to plead to pen time, and she wanted to wait to plead out next week if we could, so she could take care of her affairs. And I feel certain that she's going to plead.
Why don't we do that? Why don't y'all do the plea and I'll just reset it for sentencing, but we don't need to get a PSI, but that way we get that first part taken care of. And
I'll do that, Judge.
all right, I'll hold it while y'all do that.
I don't think another one's here.
Gustavo Vasquez. Gustavo Vasquez.
Yeah.
All right, well, this was the last reset, so I'll hold it for y'all to do. Mr. Rojas, you have Jardel Elam. It's a sentencing. Oh, where did Mr. Rojas go? Oh, hi. Jardel Elam.
Jardel Elam.
I had him tested this morning. She tested positive on May 5th. So I just want to see if there's where we are. Yeah. Mr. Elam, I'm going to have you tested this morning before we go forward. Have a seat in the jury box. Let's see if you got anything in the system. And then Nicholas Gilmore Jones, Mr. Rojas. This, Mr. Hoffpower. Good morning, sir. Are you Nicholas Gilmore Jones? And Mr. Rojas, will your client waive the formal reading of the indictment?
You will, Your Honor.
Mr. Jones, in cause number 24, DCCR 1441, you're charged with the state jail felony offense of solicitation of prostitution from March 28th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated. You'd be on probation for 5 years. You would be ordered to pay a $500 fine and to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Gilmore Jones is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and understand the nature and the consequences of your plea. Is there some history? Is that why it's a 2 over 5?
It is, Your Honor.
So I'm going to find sufficient evidence to find you guilty. However, I'm going to reset your case so that I can get a pre-sentence report done. That'll just give me more information about you, your case, any history, and then we'll go forward with sentencing at a later date. You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right there, okay? We'll see you back at sentencing. Which one? I was about to say it's not.
I'm sorry.
Okay. Miss Mitchell, come up, ma'am.
Sorry about that. I was late because I had to run back home and get the paper.
Okay, I'll recall your bond forfeiture and your Shadamon Mitchell, right?
Yes, ma'am.
So did you get someone hired?
No, ma'am, I did call around to a couple places.
Good, who'd you talk to?
I talked to Gertz Carey Law Firm. They told me it was gonna be about 5,000, but my dad said it was a little too much, because he was the one helping me pay. I called Chilean officers, no one ever gave me a call back. James R. Metcalf, I think they told me $5,000 again. Dunham and Jones gave me an offer for $3,000 a flat fee. We pay 15 up front and then 200 every other week.
Mm-hmm.
So we were thinking about going through, but we just ran out of time.
Okay, so you still think you'll be able to get someone hired?
Yes, ma'am.
Thank you for doing everything I asked you. I'll reset your case about 30 more days to give you some time to hire one of them or someone else.
Yes, ma'am.
If y'all get someone hired before the next court date, just bring that reset notice that you get today to the lawyer.
Yes, ma'am.
If for some reason it's not going to work with them, make sure you call some others, bring me those names, and we'll discuss your options when you come back. Okay? All right, you can step in front of the clerk and she'll give you your reset notice. See, Mr. Is Mr. Brewer get that rejection sign? I guess not yet, huh? Okay, that's fine. I'm not in a hurry for him. Let's see, Miss DeLage, we haven't seen her. Mr. Galmore, Mr. Gertz, Mr. Crenshaw. I saw Brittany come through. And then Macon's down in Holden. Yeah. Yep. 'Cause that's. Okay.
Cheryl Manuel.
You need to stop and talk to probation before you leave the courtroom today, and she's sitting at that desk right there, okay? We'll see you back at sentencing. Good morning. Are you Shalora Dawson? And Ms. Dawson was previously in court, entered a plea of guilty to the... All right, we'll see you back then on the 2nd at 9 o'clock.
Yes, ma'am.
Okay, thank you.
We just need to go through the motion of Gustavo.
Okay. Gustavo, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you, Parker, on Rochelle Manuel. Tim. All right, ma'am, again, you're Rochelle Manuel, and will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Manuel, in cause number 24, DCCR 1050, you're charged with the second-degree felony offense of aggravated assault causing serious bodily injury from April 5th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like that agreement's for a 3-year term in prison. Is that your understanding?
Yes.
And it's your understanding I'm going to take the plea today. I'm going to reset it for sentencing next week.
Yes, ma'am.
And we'll talk about some important things about that in just a minute, but that's what you want me to do, correct? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
All right, state tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Manuel's not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, but I'm going to hold that and I'm going to reset your case for 1 week for sentencing. Actually, I guess we could do it on Tuesday. We don't have a Monday docket. Is Tuesday big? Should we do, I'm gonna reset it for 2 weeks. I think that'll be easy. No, let's do it next Tuesday.
Yes, ma'am.
June's 2 weeks. Okay, we're gonna reset you for 2 weeks so that you come back on a Monday.
Yes,
Because we don't have a Monday docket next week.
Yes.
So a couple things about that are very important. Obviously, if you don't show up on the 2nd to turn yourself in and for me to sentence you, this plea agreement's gone and things could be a whole lot worse. You understand?
Yes, ma'am.
If you're arrested for anything between now and that court date, things could obviously go bad and I don't have to accept the agreement. You understand?
Yes, ma'am.
All right, we'll see you back then on the 2nd at 9 o'clock.
Yes, ma'am.
Okay, thank you.
We just need to go through the motion of Gustavo.
Okay. Gustavo Chavez, 23-41422.
Vasquez.
Vasquez. What did I say?
Okay,
Vasquez.
it's Gomez Vasquez. You said Gomez Vasquez. What?
I thought that's what you said.
I thought I did, but I
I
don't
thought you said
know.
Gomez.
I might have
You
said.
Vasquez.
I don't know.
Good morning, sir. You're Gustavo Gomez Vasquez. And,
Oh, she said Chavez.
oh, I did? I just totally renamed you then. I'm sorry.
We have that Gustavo Chavez.
I do. I have that name, so hold on just a second. Let me get this pulled up the right way.
Oh. I didn't give you.
On the last one.
Oh, did they?
Oh, they didn't
Oh, I didn't
sign
get her
it.
to sign it. I'll bring back the sentencing.
Okay. All right, Mr. Gomez Vasquez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you, sir. And will your client waive the formal reading of the motion?
You will, Your Honor.
I have a motion to revoke your unadjudicated probation. It shows that you were placed on probation March 11th of 2024 for the second-degree felony offense of indecency with a child. And that was a 10-year deferred probation. Is that correct? It alleges that you violated your probation. Count 1 alleges that you failed to successfully enter and complete an approved sex offender treatment program. Is that true or not true?
The program, I've gone to those classes.
Just, is it true or not true? If it's not true, then we'll just have a hearing. Okay. Not true to count 1?
Yes, ma'am.
All right. Count 2 alleges that you failed to register with the sex offender tracking program. Is that true or not true?
No, it's true, but
Okay. So did you enter your plea of true to count 2 freely and voluntarily? And because count 2 is true. All right, then I'm going to find that you entered your plea of true to count 2 freely and voluntarily. Find that count true, find sufficient evidence to find you guilty and revoke your probation, but I'm going to reset your case for a sentencing hearing. Mr. Hoffpower, you can bring whoever with regard to count 1, please.
Probation officer.
I don't anticipate that would be long, so we'll just do it on a regular day.
Just for the record, so he understands what I've explained to him, I'm explaining to the court, is that he has explanations of things he's done.
Sure.
And I've said, that, but it's whether you did this or not. And so he has some reasoning or explanation for all this. Which I
We'll
told
get the
court we'll hear.
explanations at a sentencing hearing. And so what'll happen is I'm going to have probation do an updated pre-sentence report before a sentencing. That'll give me more information about what's been going on. And then when we come back, Mr. Parker will be able to present to me anything you think is important on your behalf. Mr. Hoffpower will be able to bring any witnesses with regard to that count, and then I'll decide what to do on that day. Okay? All right, you are free to go. Thank you.
thank you.
Ms. Holmes, you have Shalora Dawson. It's a sentencing. No, just put her in jail. Good morning. Are you Shalora Dawson? And Ms. Dawson was previously in court, entered a plea of guilty to the state jail felony offense of abandoning or endangering a child. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, sir.
Ms. Dawson, if I test you this morning, you gonna have anything in your system?
Oh, no, ma'am, I did.
Let's, we're gonna double check this morning before we go
Okay.
forward. Have a seat in the jury box.
On my thing, she told me to tell the truth.
Yes.
I bought her the dispensaries and everything, but she said that she was
But-
THC.
Right, so did they tell you probably shouldn't be doing that, so you don't test positive, so I don't think you're using something illegal?
No, because it wasn't me smoking, it was something like a gummy that was supposed to help relax me.
Right, but if it's gonna test positive, then I'm gonna assume the worst. So we'll get to that in a minute. I wanna test you this morning, see what's in your system, then we'll go forward in a minute. Have a seat over there in that jury box. Willie Richards, Ms. Holmes, it's a sentencing.
He's outside.
Willie Richard.
Just, I've got my stuff, I've already dismissed. There was two of them, and I dismissed one of them outright. You have a dismissal.
On Richards.
Just follow on Richard.
Unless it's already been dismissed, it looks like, because it's not on the docket. Good morning, sir. You're Willie Richards. Mr. Richards, you were previously in court, entered a plea of guilty to the second-degree felony offense of indecency with a child by sexual contact. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Yes, sir.
Are there any additions or corrections?
No.
No, I just had a couple questions.
Okay.
In regards to the supervision plan, Mr. Richards, he plays the drums at his church every Sunday. Does that need to cease, or we were just needing clarification so he's not in violation?
At a regular service or something specifically with regard to kids or?
At regular church service on Sunday.
You have to play guitar.
The guitar, I'm sorry.
Okay. Yeah, I'll look at that in a second. Anything else that you want?
And the polygraph, we were just wondering what that was.
That's part of probation for any sex offender.
Oh, okay.
Yeah,
That was it.
that is to make sure that they're doing what they're supposed to and not doing what they're not supposed to be doing. I'm assuming, Mr. Hoffpower, that you've visited with the family and I would think that
There is a, if you read an order, there is a restraining order for the complex where this occurred.
Right.
And it's in place.
Well, and I would think that somewhat the special needs of the victim is why this offer
Right.
was made.
Yes, sir.
I mean, Mr. Richards, this is, you're 60? I mean, what you did was ridiculously terrible to a young girl that already has her own set of issues. All right. I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty. However, I am going to follow the agreement that you made with the district attorney's office and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and you're ordered to follow all of the rules and conditions of probation. That includes obviously being on the sex offender caseload, following all of those recommendations. I will allow you to play in the band at church. You are, however, specifically ordered, and part of your probation is you cannot be alone with any child under the age of 18. Period, ever, never. Do you understand? You obviously cannot be on the premises of the Carlisle apartments. You can't be anywhere near or have any contact or communication with the victim in this case as well. If you do everything you're supposed to, get the treatment that you're supposed to get, make sure that you're doing all of that, then this is an incredible opportunity because you do not have this conviction on your record. And if you successfully complete the probation, at the end, the case is dismissed and you will never have this conviction. The other side of that, though, is if you violate any condition of probation, you will be brought back into court, you will be found guilty, and then I can sentence you to prison anywhere in the range of punishment, which is up to 20 years in prison. Do you understand? All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. All right, good luck to you, sir.
Yes.
You've got Daryl Spencer, Ms. Holmes?
Yes.
Daryl Spencer?
He's here. I didn't know he was here. I thought he was still there. I thought he was still there. He does? He just got out of Orange. Yeah, that's the one, he was in Orange County. I thought he was still there. I didn't know he was here today. Does he have a warrant here? Hold on, Mom.
Yes.
Okay, he said he has a traffic ticket warrant, so you'll have to go in today. All right, you're Daryl Spencer. And Mr. Spencer, you're charged here with possession of marijuana as well as evading arrest or detention with the use of a vehicle. And is there an announcement?
Not yet, Judge.
Okay.
I need to meet with him.
So I'm going to do a normal reset about 30 days. So you'll go in custody today. If you set out your tickets or pay them, whatever happens, that shouldn't take that long. As soon as you're out, the first thing you do is contact Ms. Holmes so you guys can go over whatever it is she knows about your case, and we'll see what the announcement is at the next court date. All right, you can go back with the bailiff. Ms. Pratt, are you gonna be able to use the restroom this morning?
Well, I was gonna talk to you about my medical.
Okay,
I don't know.
they did, but I know that even with that issue, you still go to the restroom.
3 days or so, yeah.
So why are you
We
come
can
up?
draw blood, I mean.
Well, we're not gonna draw blood. Come up here.
Put your water here. Oh, my water. Yes.
You're gonna go before the judge?
When's the last time you smoked marijuana?
It was one of those little gummy things from the vape store.
Uh-huh.
I guess it's THC, but.
Why are you?
I just said marijuana, but it's THC, which I thought was the same.
It is the same. It'll show positive.
Okay.
It's all derived from the same stuff. And if you have a felony court case pending, I would think you wouldn't want to have anything in your system that would have you test positive, right?
Well, I'm not sure if it will. It was like a month ago. I'm on probation. I've been on it for almost a year. It's in
From where?
Jasper County,
Okay.
and they know about all my medical. I need a heart valve replacement, and I have a liver failure, and now it's resulted to the kidneys.
Okay.
So he,
Sounds like you need to quit doing stuff to get yourself in trouble so you can
I do.
stay
I
out
do,
and
like,
take care of yourself.
I do, I know.
So, what I'm going to do this morning, Ms. Pratt, is reset your case for you to hire a lawyer. You need to try to get a lawyer hired before the next court date.
Okay.
If you do, bring the reset notice to them, and they'll tell you what you need to do. I'm also ordering as a condition of your probation that you have a drug patch. You need to have a drug patch put on within 24 hours. And you will, probation, when you're walking out, the lady sitting at that desk can give you a list of places where you can get that done. You have to have it on, you wear it 2 weeks, you have to show up every 2 weeks to have it tested. If it's not testable, I'm going to assume it's positive. If you don't go show up when you're supposed to or go get it, I'm going to assume that you're using something that's illegal. Your bond will be raised and you'll be in jail. Do you understand?
I do.
Okay, so you need to have that on within 24 hours. So by tomorrow, you need to have the drug patch on.
Okay.
And then don't use anything that could potentially test positive for anything. It's that simple. If you're on a probation and you've got a felony pending, you need to be crystal clean, all right?
Like 10 medicines that I'm on.
If you are on medication that shows you to test positive, that's one thing. A gummy from the corner store is not medication, right? So bring your list of medications. If you test positive, show them. We understand. I know what things test positive for other things. But gummies aren't one of them. All right, step in front of the clerk. She'll give you your reset notice.
Make that a condition of her bond, because I can't do anything with her probation in Jasper.
Yeah. It's just a bond here.
Okay, condition of the bond.
Yeah, did I say that the other way?
Yes, ma'am.
Condition of bond.
That's okay, just making sure. And sign it and talk to my lawyer about it. Well,
Mr. Macon, you have Matthew Baxter. Okay, I'll call it as soon as it's ready. What about Patterson? I'll hold those when they're both ready. I'll get you back up here. Thank you. Mr. Let's see, Crenshaw.
It's okay, so whenever it's on the initial, that's just how.
Mr. Galmore, you have James Rucker. Morning.
How are you?
Morning. All right, good morning. You're James Rucker?
Yes, ma'am.
All right, where are we?
Judge, we basically completed discovery.
Okay.
We're gonna need a hearing on the motion to quash on one of the indictments. And so,
Okay.
We kind of talked about our schedule and the timing. We were asking for 3 weeks, the week of June 16th, whatever day, if that week is okay.
Has it been filed yet?
It's not out filed, probably this afternoon though.
Okay.
They know what it's gonna say. It's gonna say.
That's the week, we're down the week of the 16th.
Then the week after that, Judge Nealon will be out for 3 weeks, starting next week, and as a result, I'm covering intake those 3 weeks.
Okay, so just sometime after that, I'll figure out the date.
I am out the next week though. That's the reason.
Just make sure y'all have everything, make sure you've turned in a,
Vacation.
Yes.
I don't know if I have or not. Yes.
if you'll do that, please, that way we can,
Know about it.
well, yeah, because if we know about it, then we can reschedule it. So it's much easier for y'all to do those, get any vacation letters in, including, but we'll look after that date, after the 23rd or 2nd, whatever that is. But whatever days you're out, just make sure that you have that filed, Mr. Galmore, and we'll schedule around that.
Will do.
Okay? All right. You're free to go. Stay in touch with Mr. Galmore. He'll let you know when you need to be back.
Yes, ma'am.
Did you ever get in touch with Ms. DeLage? So I've got Corey was just in here. DeLage is coming. Brooks is coming. We're waiting on Ms. Holmes. And Mr. Macon.
Good morning, Your Honor.
Good morning. You got your discovery certification?
Do we do that on the plea day?
Mhm.
On the sentencing day? So,
If you'll just get the signed part, you can bring your, just email your attachment later. If you'll get him to sign it today, that would be perfect. And you can email the attachment to Ms. Holmes. All right, so are you Justin Chapa? And I am going to take judicial notice of the court's file before.
A trial date, it's a serious case. We have expert witnesses that'll be involved in the case, so.
Plea of not guilty, going to be the attorney of record, and are we setting a status date for him? And what day? September 22nd.
Thank you, Judge.
All right. State versus Eric Lee Aldridge.
Same case number?
Yes.
Yeah, I represent all of them.
You represent all of them?
Well, same announcement.
Oh, both of them?
We'll waive formal reading and
Right.
enter a plea of not guilty.
Roger Wanick is the attorney. Waive the formal reading, enter a plea of not guilty, set for status on September 22nd. Thank you. When you have some people here, let me know who.
Eddie said on that same.
Okay, as soon as you get a list of who we have here, let me know. All right, page 2 of the docket. 2025 CR 42, State versus Hunter Blight Bagwell. That's Mr. Flanagan's case. Mr. Flanagan is a witness in the the Holly Bobo PCR case, I think, down in, he's actually on his way.
That one's for possible plea, so I'd ask for a second calling, Your Honor.
All right. Put it on the second call.
Thank you, sir.
2023 CR 21, State versus Gary Ray Baker Jr., Mr. Scruggs. Second call. 2022 CR 305, State versus Amanda Lynn Bolin. Review.
Judge, that was a retirement. She has completed the terms of that, and that case is dismissed.
And what?
That case is dismissed.
Case is dismissed on the state's motion, compliance with the agreement. 2023 CR 192, State versus James Edward Boyd. Public Defender.
Got Mr. James Boyd here today for a status. Our plan was to request another status date for Mr. Boyd. I think
Why?
There's no objection from the state.
Why are we getting another status date? Turn your microphone on.
This case is in retirement status. I have asked repeatedly that based on his health conditions that he not be brought into court. We just need to reset it for another year to continue tracking.
All right, you want to put it on September the 22nd?
Yes, Judge.
All right, thank you. September 22nd.
Thank you, Judge.
Thank you. 2025 CR 90, State versus Patrick Bucciarelli, and that is Mr. Flanagan's case. I assume we'll pass that. What is the state's motion in that case?
It was a motion to get a passcode, but it's not contested. Mr. Flanagan's bringing those with him, and then we just need to set a motion date, I think, for other motions.
All right, let's let Mr. Flanagan
Yeah,
arrive.
we'll wait for Mr. Flanagan to
All
get
right,
that
we'll
motion
put it
done.
on the second call.
Thank you.
2022 CR 393, State versus Ashley Brooke Burnett, Mr. Spratt.
It should be for a plea, Judge.
You know, I had my rear end chewed out by Judge Martin so many times that I realized what he said was, be early as you want to be, just don't be late. There was a lot of wisdom in that, so. All right, 2023 CR 156, State versus Shonda Alice Carver. Mr. Wilkerson.
CR 156 was set for status, and I thought I had it worked out, but she's gotten new charges. She has an arraignment on 2023 CR 105, so if the court would like to appoint me on that, I can do that.
All right, so we need to arraign her on the 2025 CR 105. You want a formal reading of that indictment?
No, Your Honor, waive formal reading. Acknowledge receipt of the indictment.
All right,
Where
plea of
is
not
she?
guilty is entered.
Where is Miss Carver?
You don't know where she is?
I don't.
Well, she's supposed to be here for arraignment. We'll give you a minute to try to check on her. I'll put it on the second call. If she's not here to answer the arraignment or to be arraigned, then we'll be issuing a warrant for her.
Yes, Your Honor.
All right, thank you. Come up, talk to the clerk if you want to. 2025 CR 105, State versus Shonda Alice, well, I'm sorry, that was the one I just talked to. 2022 CR 323, State versus Sonia Cervantes Mendez. Good morning. Are you Miss Sonia M. Cervantes Mendez?
Yes, sir.
Cervantes Mendez, you are here to be arraigned on a charge of theft up to $1,000. That is misdemeanor theft. You have the right to an attorney. Do you wish to have a lawyer represent you?
Mr. Flanagan is my attorney.
All right, so he is representing you?
Yes, sir.
He is on his way. I'm going to put you on the second call.
Okay.
So you need to talk with him when he gets here to finalize and make sure that he is representing you. So
Yes, Your Honor.
sometimes there can be a little bit of confusion about that. So.
Yes, Your Honor.
All right, thank you. 2024 CR 109, State versus Kristen Clark. Actually, this is Jamie J. Clark. Ms. Wilkerson?
That's my case. It's set for status. I was just informed that they've acquired a expert witness. So
Okay.
I don't.
Who
think
has
this can-
acquired an expert witness?
The state has acquired an expert witness.
I think this is just for status. This is the daycare case.
All right. So the review date needs to be reset for September then? All right, September the 22nd. On the State versus Kristen Clark, that is Mr. Walker's. He is on Zoom.
He is not logged in. I believe he's also in court in Kentucky, Your Honor. Oh, yes. So we might need to second call her. That's okay.
I'll put it on second call.
Okay, thank you.
2023 CR 178, State versus Randall L. Clark.
On this, Your Honor, we've submitted a new forensic evaluation order, and I think we just need another status date.
All right, so pending the results of the forensic evaluation, we're going to pass it to September 22nd.
Yes, sir.
All right, September 22nd. 2025 CR 37, State versus Logan Austin Cooper. Mr. Wainick.
We'll also waive formal reading, enter a plea of not guilty.
Plea of not guilty. Do you want to set the status for September the 22nd?
Sounds good to me.
September 22nd. 2024 CR 109, State versus Jordan H. Darnell. Mr. Cox.
So my client is going to tender a no-local injury plea today, Your Honor.
All right, I've been handed a document indicating that Ms. Darnell is going to be entering a plea under 4035 313. Is that correct?
State in negotiating this case will offer
You understand you'll have to testify truthfully?
Yes, sir.
All right. Then I've been handed a document indicating that there are 12 counts in the indictment. And I'm not going to, at this point, go through them, but you're going to be entering a plea of no contest to count 2. Count 1 is dismissed. Count 3 is dismissed. But the remaining counts, in each of those counts, you're going to have a count attempted child abuse and receive a sentence of 1 year. And what is the effective total sentence in this case? 5 years? All right. So those are running, some are running consecutive, some are running concurrent with each other, but it's an effective 5 years of probation. Do you understand that?
Yes, sir.
Raise your right hand. Let's place you under oath.
Yes, ma'am.
State your full name for the record.
Jordan Hannah Darnell.
Ms. Darnell, you're here today charged with a multi-count indictment involving, and this is the case that involves a daycare center over in Stewart County, correct? Right, and you heard me go through what the effective balance of it is, but have you and Mr. Cox had a chance to go over the indictment, discuss the range of punishment you're facing, the state's evidence, and any possible defenses you might have?
Yes, sir.
Well, it's indicated that you want to enter a plea of nolo contendere. What that means is you're not going to admit you did anything wrong, but you're not going to contest the state's evidence. And they're going to tell me what their evidence would be if this case went to trial. Do you understand that?
Yes, sir.
You understand that a plea under this 4035-313 is basically what we call judicial diversion. And I'll get to that again in a moment, but that's a special consideration for someone who has no prior record. You understand that?
Yes, sir.
All right. Do you understand that you have the right to plead not guilty and to have a speedy and public trial by jury in this court? You understand if you went to trial, you'd have the right to have a lawyer and have one appointed if you cannot afford your own.
Yes, sir.
Do you understand that if you went to trial, you'd be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict will have to be unanimous before you could be convicted of anything?
Yes, sir.
Do you understand that if you went to trial, you and Mr. Cox could confront and cross-examine every witness the state called to testify, and you can bring in your own witnesses by using a subpoena?
Yes, sir.
Do you understand that at trial you would be presumed to be innocent? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial. Do you understand that if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes, sir.
You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
Do you understand that that's going to result in a number of convictions? Now, I explained to you that this 4035-313 is a process that's only available to people who have no prior record and have some reason why they should be given special consideration. Do you understand that what that means is you're handing me these pleas, and for 5 years you're going to be on probation. If you successfully complete all of the terms of your probation, which does include testifying truthfully against anyone else who might go to trial in this case, then at the end of that 5-year sentence, you can apply to have your record expunged. It won't happen automatically. You'll have to ask the court to do that, but you understand that's an option that you will have.
Yes, sir.
You understand that if you violate that probation and you don't comply with all of the terms, then these will become permanent convictions, and they will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime.
Yes,
You
sir.
understand all of that? All right. You understand everything I've explained to you?
Yes, sir.
Do you want to enter this plea according to that agreement?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes.
Anyone forcing you to do this against your will? You understand that I can't accept your plea unless I'm satisfied that there is a basis for it and that you are in fact guilty of these charges. Now, how does the state wish to proceed? Since part of this agreement, it's a no contest plea, but part of the agreement is that she'll testify truthfully against the co-defendants if any of them go to trial, correct? So how do you wish to plead? Do you want her to testify on the record and make an allocation right now? Or do you? All right. I want you to listen as the state, and if you'll step to the side, let's let General Allen, whose voice is a little raspy today, let's let her, I want you to listen because this is what they're expecting you to be able to testify in conjunction with. You understand that? All right.
Your Honor, the state would put on proof that between May 1st of 2021 and March 25th of 2022, the defendant, Jordan H. Darnell, was under the supervision of Jamie J. Clark, a co-defendant in this case at Mimi's Daycare in Stewart County, Tennessee. And during those dates, under the supervision and at the direction of Jamie Clark, Ms. Darnell periodically gave 30 milligrams of melatonin to children under the ages of 8 in the counts listed in the indictment, Your Honor, at Mimi's daycare. While those children were at Mimi's daycare as a result of the melatonin, had night terrors, were vomiting, weren't sleeping at night, and it had deteriorous effects on their physical and mental health, Your Honor. And that's what the state would put on for proof. And also, while working there, Kristen Clark and Ethan Pulley and Jamie Clark, Your Honor, did try and take the camera down that had proof of administering of the melatonin, and we're going to hide it from law enforcement. It was eventually turned in, Your Honor. But that is the basis of what the state would ask Ms. Darnell to testify to. And we would also, I mean, it'll be more detailed at trial, Your Honor, but that's the basis of the facts.
All right, Ms. Darnell, I'm not asking, I guess I am asking, normally I would say I'm not asking you to agree with those facts, but you understand that's what the state expects you to testify truthfully to at trial, correct?
Yes, sir.
All right, you understand everything that I've explained to you thus far and what your obligation will be?
Yes, sir.
And you understand if you don't testify truthfully at trial, then that will violate the terms of your probation?
Yes, sir.
All right. Are you satisfied with your attorney services?
Yes.
You feel like Mr. Cox has done a good job of representing you competently?
Yes.
Mr. Cox, do you know of any reason she should not enter this plea? Anything further from the state? Then Jordan Darnell in docket number 2023 CR 1, upon your plea of no contest to count 1 is dismissed, count 2, attempted child abuse, you're found guilty, sentenced to 1 year in the Tennessee Department of Corrections, suspended to probation. And that will be a condition of your probation, is you will not be able to work for a licensed daycare center while on probation. Count 4, your count 3 is dismissed. Count 4, you're sentenced to 1 year consecutive to count 2 plus costs. Count 5, you're sentenced to 1 year concurrent with count 4, a $50 fine and cost. Count 6, you're sentenced to 1 year consecutive to count 5. Count 7, you're sentenced to 1 year concurrent with count 6 and a $50 fine. Count 8, you're sentenced to 1 year concurrent with count 7. Count 9, you're sentenced to 1 year consecutive to count 8, $50 fine and cost. Count 10, you're sentenced to 1 year concurrent with count 9. Count 11, you're sentenced to 1 year consecutive to count 10, a $50 fine and cost. Count 12, you're sentenced to 1 year concurrent with count 11. This will all be on supervised probation. She'll need to see the probation department before she leaves today.
Your Honor, I may have wrote it in there wrong, but there's only one cost for all of it.
Okay, well, there's several times it's mentioned. I just want to make sure.
There's just $50 fines on the odd counts,
All right.
but then there was just one cost.
Court costs of 1 count. Thank you.
That's all I have, Judge Monday.
You may. Sorry. You want? Yes. Twenty 23 CR 229, State versus Ted Bradley Davenport.
I think that matter is here for status and maybe
If you get your assessment done, you get released, you still need to come back here before me on June 9th. Up to us. The court will be in a brief recess until that happens. The 14B District Court is now back in session. The court will call the case of the State of Michigan versus James Wilson, case number 24 FB 1399.
Anthony Mansour on behalf of Mr. James Wilson, who appears today via Zoom from the Washtenaw County Jail. James, when you're unmuted, can you state your name for the judge, please? There you go.
All right, James Wilson.
Thank you. All right, we're back here today for a review. We adjourn this matter so that we can look into the MRT, CMH, and ADOBA, which is regarding his Institute for something leadership and restaurant institute, interstate something. I don't know. I can't read my own handwriting. So look into that.
Your Honor, I know Ms. Moeller been working with Mr. Wilson a lot on this case. I know you and her know obviously more about this case than I do, but she let me know that she did get an update from CMH and Sarah Stewart. I believe they are working towards getting him into the CMH program. The MRT program, however, is not going to be available according to what Ms. Moeller was told. And the other program that you stated earlier, or just now, is not an option either.
When you say they're working on getting him into this, all I wanted was a CMH assessment. How come that hasn't happened yet?
I'm unsure. I don't know if Mr. Wilson has more intel than I do. It seems like Ms. Moeller tried to reach out to Ms. Stewart. I don't know where, if they've continued. Go ahead.
You don't mind.
Yeah.
Mr. Wilson.
What happened is I've seen it getting to these little altercations that is all right. I go to show one of the. I ordered this meal or whatever, and I didn't get my meal. The meal was supposed to come at 2 o'clock or 2:15. It's 5 o'clock. I want to know what do I do with this meal since I haven't received it. I paid $11.50 for it. So I go to see what's going on with the meal. And when they handed out the dinner tray, the officer pushes me 3 times back in my cell, and so I before the 4th time I hit him and he pushed me again and we got into it. Oh my God!
All right.
So it ruined my certificates of completion. I had from the Edward Institute. I had I completed 9 courses, 9 college courses that they had. I have completed these courses, and it just ruined everything that I had set up. I'm sitting up here thinking because they got free room and board, they teach you their skills, and plus, once you get down to Ohio, they will pay you for their classes. Now I'm sitting up here
All right, Mr. Wilson, that's good. That's good. Let's see what the judge wants to do. I'm sorry. Sorry, Your Honor.
Wilson was sentenced back here to 55 days, credit for 77. It could be released upon us.
Your Honor, I think you cut off a little bit after you said he was sentenced.
So everything, in other words, to 365 days, and he could be released. Oh, and credit for 77, he could be released from custody upon approval to upon a CMH assessment or completion of MRT. MRT is not an option. Apparently, he got kicked out of the program that he was doing, and now the only option is the CMH assessment. It sounds like is what we need. Since it sounds like I'm concerned now that he may have a new charge. I mean, there's just a lot going on here.
Yeah, I'm sorry. I'm not too, like I said, I'm not too aware of this, but if we could just request an adjournment, I could try to reach out or wait till Ms. Moeller comes back. She had a family emergency, so she knows What's
I
going
don't,
on?
I don't believe I have a new charge, Your Honor. It's just that-
Mr. Wilson, no, let's not even push that issue. Let's just leave that alone. Your Honor, if we could request an adjournment on this, so we can get any update with Sarah Stewart and CMH to see how that program is coming along.
Contact info for, do you have contact?
Your Honor, it's very hard to hear you. I don't know what you.
All right, let's do oops. Do you have the contact info for Sarah Stewart?
Yeah, Your Honor, I've reached out to her in the past. We have her email and whatnot.
Can you please forward it to me and my staff? I'll reach out to her myself. I mean, he's been in there since March. I don't understand why it takes so long to get CMH assessment done.
Yeah, Your Honor, that's understandable. I'll get you what I have at least.
Thank you. Yes. Thank you. May 22nd. Okay. That's when the assessment is being done? Okay. All right, so it looks like the assessment's being done on May 22nd. I'll see him back here on June. I'm still gonna do the same thing, June 9th, 2025 at 9 a.m. His sentence is continued till assessment. So if they do that assessment, he can be released, like I had said before, but I still want to see him on June 9th. So, sir, if you get your assessment done, and you get released, you still need to come back here before me on June 9th, okay? On Zoom. You're muted, but you need to be back here on June 9th.
Thanks, Your Honor.
You're welcome. So we'll be waiting for the next defendant to be brought from the jail. Good day.
Take care.
Hearing. And I think that's our docket for today.
Thank you. No failure to appears, huh?
Yes, we did those already.
Oh, maybe I was in a breakout room. Lucky me. See you guys.
See, you. Have a good day.
Take care.
You need to go back down to court services and check back in and schedule your interview, okay? Thank you. We did it, 11:59. Look at that, Justin.
Final date, I'm not sure, but Judge, there are kind of multiple issues as I understand it. I think the alleged victim is currently undergoing maybe an inpatient competency test, and there's some discovery that has not been turned over as far as some phone records.
All right, so we need to reset this. Is that September 22nd date what you want?
Yes, sir.
September 22nd? You don't want to wait around for 40 pages? Erica Ann Tibble Davenport. All right, so that will be set for September the 22nd as well.
Thank you, Your Honor.
2023 CR 107 State versus Darrell Lamont Dawson. Darrell Lamont Dawson for attorney status, final plea day status. Mr. Dawson have a bond? Well, this is his attorney status, so he's supposed to be hiring an attorney, and it is his final plea day, so. Be a conditional forfeiture in the bond in amount of $30,000. Capias for the defendant, Sarah Fleischer, the bonding company. Final forfeiture will be set for, with your criminal docket call be on November the 10th. What's your VOP day in November? Final forfeiture will be set for November 24th. New bond will be $60,000. 2023 CR 328, State versus Caleb Dwayne Dawson.
Mr. Dawson continues in the recovery court program at DC4. We have an update from the counselor there.
May I, Your Honor, I apologize. May I be excused for the time being? I see Ms. Gillette's here now. I think my docket's fairly well set at this point in time, but I would like to get into the commission meeting.
Okay, thank you, Mr. Dean.
Thank you.
All right, would the parties please announce appearances now on the Hunt matter?
May it please the court, the state appears by Jill Gillette, county attorney.
Richard Paul on behalf of Heather Hunt, who appears by Zoom.
All right, we've been talking about making 807 the prime with 24661 tagging still with it, which brings us to Heather Hunt. Parties, any chance I can I'm going to put you in a breakout room if you don't have this resolved.
Judge, we don't have it resolved. Miss Gillette and I spoke last week on it. We both knew that Turner was going to be prime, and I think both parties are going to ask to continue Hunt at this time.
Well, these cases are getting old. We need to get them resolved, as you all know.
Judge,
The facts are getting
resolved as
stale.
quickly as possible.
Well, I just don't understand why it takes 2 or 3 years to get cases resolved. Ms. Hunt's looking at a DUI and 4 counts of endangering a child. And you've talked this thing to as far as you can talk it, Ms. Gillette?
I believe so, Your Honor. If you want to put Mr. Pano in a breakout room, we can visit briefly, but I don't believe we'll get a big resolution. But I don't mind talking.
All right, I'd like for you two to go to a breakout room, but before you do, Ms. Gillette, are there any announcements on the Chase Miller's case? The one
Yes.
that can,
Yes, Your Honor. If
All
you'd
right.
like me to speak.
all right, we'll be in recess on Hunt. We'll go on the record in 24 CR 12, State of Kansas versus Chad Cooper, County Attorney Jill Gillette for the state, Attorney Chase Miller for the defendant, who also appears in person. Mr. Miller, any announcements on that?
Yes, Your Honor. May it please the court. We have tentatively resolved this case by a diversion. That application has been submitted and we're waiting on review. So
When did you submit that application?
this morning.
This morning, okay. So we can put that maybe on a misdemeanor control docket, and if it's diverted, it'll go off docket. If it's not diverted, maybe okay. So is Missy with us? Ms. Gillette, when's our next available misdemeanor docket that you?
I'm here, Judge.
Okay, you are. Missy, we need a misdemeanor control docket for Chad Cooper.
Do you want to go out about a month?
Is that enough time, council
I
parties?
believe so.
Yes.
Okay. How about June 24th at 3:30?
June 24th, 3:30.
I can make that work.
Okay. Now, if that is not diverted, will that be for plea, or are you going to continue that for jury trial, Mr. Miller?
Well, I think I'd have to unfortunately discuss that further with my client, but we'd certainly have that answer ready at that time if it comes to it.
Very good. All right, if there's nothing further, then we will be in recess on Cooper with Mr. Cooper continuing on your bond. Mr. Cooper, you're going to have the same conditions with the added condition that you reappear June 24th at 3:30 if your attorney does not tell you otherwise. Can you unmute and indicate that you are following us? Click that little red icon that looks like a microphone if you have it.
While he sorts that, Your Honor, do we have Zoom authorization for that future date?
Absolutely, yes. Thank you for asking and clarifying that.
Thank you.
Mr. Cooper, if you're hearing me, give me a thumbs up. He shut off his video. Okay,
There we go.
all right. Thank you. I see a thumbs up. You're excused at this time, Mr. Cooper. Mr. Miller, you're excused as well.
Thank you.
You're welcome. And now we're going into a recess on Hunt and Missy. Who's running my Zoom today? Is that Jen that's running the Zoom?
Yes, Your Honor.
And Jen, if you would please put Miss Gillette and Mr. Paul in a breakout room for another ditch effort of trying to resolve this. And if you want to revisit Turner, that'd be perfectly agreeable too. Thank you. Are there any on the Butler County docket that are definitely for plea or dismissal?
Your Honor, any
Your Honor, Annie Upton appears with Philip Moore. Ours will be for a plea for a second offense DUI.
That's, you said hit the defendant is Burrows?
Philip Moore.
Oh, Philip Moore, I'm sorry. All right. Anyone else?
Your Honor, the Tyson Arnold case,
Yes.
a journal entry of dismissal was filed minutes ago.
Mr. Regier, that's correct. Mr. Regier?
One moment, Your Honor.
That's correct, Your Honor.
That would appear accurate, Your Honor.
All right, thank you. All right, who's at the Butler County Detention Facility? I'm sorry, sir, you're muted.
Your Honor, we have Mr. Hughes and Mr. Nelson here at the jail.
And are they both Mr. Patterson's clients?
I believe so, Your Honor.
Mr. Patterson, is he available or is he in a breakout room?
He is currently in a breakout room.
Deputy at the jail, has he talked to his clients lately? Do you know?
Not that I'm aware of, Your Honor.
All right, well, let's see if we can get that done in the near future, like within the next few minutes. Okay, we have back, Miss Gillette, did you get to go in the breakout room? Okay. Jen, we needed Miss Gillette in a breakout room with Mr. Paw. Okay, there we go. It looks like maybe. Yeah. All right, so let's go on the record in Arnold. So we can let a couple of people go on Arnold. We are on the record in 2024 CR 369, State of Kansas versus Tyson Keith Arnold. Please announce appearances.
Jerry Regier on behalf of the state.
Gail Jensen for Tyson Arnold.
That's not Tyson Arnold behind you, is it?
No, this is Mr. Martinez. That's the only other case I've got. Mr. Arnold's not here because Judge Rickey announced the dismissal from the bench back in April when a plea was done that disposed of this case along with another one that was pending before him on his pretrial docket.
I see. And Mr. Regier, is it correct that that journal entry has today been filed to dismiss this case officially?
Your Honor, that is what the state's notes would appear to reflect, Your Honor.
All right, so that was dismissed with prejudice per plea agreement in Judge Rickey's felony case.
And Your Honor, for the court's edification, what I would tell the court is there does appear to be another Butler County case 24 CR 424. It would appear that that matter was previously set for pretrial on April 1st before Chief Judge Rickey, at which time the case did proceed to disposition.
Oh, very well. Then Arnold is officially dismissed in 24 CR 369, and the defendant is excused if he is here. His attorney would be, but you said you have Mr. Martinez with you, Mr. Jensen?
Yes, Your Honor, I do. It's 24 CR 013.
We'll be on the record in 2024 CR 13, State of Kansas versus Luis Angel Martinez. Please announce appearances.
Jerry Regier on behalf of the state.
Gail Jensen for Mr. Martinez, who appears seated to my right in my office and connected to the court by Zoom.
All right, and do we have any announcements on that, gentlemen?
Your Honor, this is much like the court heard earlier. I don't believe I'm in a position to where we could accept a plea offer. I'm also a little uncertain as to how the state would intend to proceed. It appears from reviewing the court file that an essential witness, specifically Officer Blake Weekly of the Rose Hill Police Department, was not served with a subpoena, and the message on the return of service said no longer with department, no FW, which I think meant forward. And I see no evidence of service on Michelle Martinez either. So I don't know how we would proceed, although the case from our perspective remains for trial.
This case is over a year old. It allegedly occurred, the crime of domestic battery allegedly occurred January 6, 2024. Mr. Regier, do you have witnesses ready to go Wednesday?
Your Honor, I believe that, Your Honor, the state would request a recess to review this matter further. I believe there are other prosecutors from my office who may be in a position to take up other matters, but I will need the opportunity to review this matter briefly.
Very well. And then I want, if depending on the outcome of that, we may need to have you go in a breakout room with Mr. Jensen. But we'll take a brief recess in Martinez, and then if we, well, we'll just leave it at that. Mr. Stang, do you want to take up one of your cases now, or do we need Mr. Regier for that?
Your Honor, I'm available, assuming that we're taking up Hoos.
That's the only one I think I have this morning, I hope.
Okay.
Let's take that up then. We are on the record in 2022, TR 3507, State of Kansas versus Timothy Edward Hoos. Brett Sweeney for the state, John Stang for the defendant, who also appears in person. Gentlemen, are there any agreements on this case?
Your Honor, if I may,
Yes.
this is a case that Mr. Stang and I have been having communication on for months and months. At this time, the state's going to go ahead and dismiss this case without prejudice. The court's aware DUIs can't be dismissed without, some evidentiary issues. And I think that's the case here, at least as it stands right now. So the state would go ahead and cite those evidentiary issues as a reason for dismissal without prejudice of this case. Of course, it can be refiled if need be.
Your Honor, I agree
Okay.
with the
Go ahead,
evidence.
Mr. Stang. I'm sorry, Mr. Stang, I kept cutting you off. Go ahead, please.
I would agree with the evidentiary issues. There's some insufficient evidence in this case, so I would agree with Mr. Sweeney's stance.
Well, this
And no objection.
this third time DUI allegedly occurred September 23rd of 2022, and we've had a number of years of the parties wrangling it around, looking at the evidence, and if you conclude that there is insufficient evidence, I think a dismissal would be appropriate at this time. I will grant that, as counsel said, without prejudice, where it could be refiled if appropriate. So Mr. Hoos and his counsel, Mr. Stang, are excused at this time. Thank you, counsel.
Thank you, Your Honor.
You're welcome. Let's see. Mr. Jensen, did you get the breakout room with Mr. Regier yet? No? You're muted, sir.
Your Honor, I haven't got an assignment yet. I think he was the one who wanted to go check
Right.
with other counsel and
Okay.
check the court file. I don't know that he really needed to speak to me so much.
All right. Well, we have Ms. Gillette and Mr. Paw back on our Greenwood County. We are back on the record in Greenwood County 2024, CR 235, State versus Heather, I'm sorry, TR 2024, TR 235, State versus Heather Hunt. parties as before. Ms. Gillette, Mr. Paw, any successful negotiations or announcements?
Judge, after speaking with Ms. Gillette, we both think we cannot try this in one day. We think it's going to take longer. What we had talked about is, Judge, is maybe special setting this for July 22nd. That's a Tuesday. That's a Greenwood County docket day, and there's nothing on my calendar for that day.
Missy, does it look like we could do that? If we, of course, we'll have to get authority of.
For a bench trial? Jury trial.
Jury trial.
We'd have to get special authorization from Chief Judge Ricky to do that. There's a lot involved, as you all know, with getting jurors summons.
We understand that, Judge. We're trying to be accommodating.
And we do need to do what we need to do. So, Missy, let's tentatively put that at that point. And if it doesn't work, then we'll all get back together and.
July 22nd?
9 a.m., yes.
Okay, that's a Tuesday, so we'd have to break for first appearances at 1:30.
Unless we could get someone else to cover those. You are absolutely right. All right, so we have Michelle Turner as Greenwood Prime this Wednesday at 9 in 23 TR 807, and we have Heather Hunt, Jury Trial Prime, July 22nd at 9 a.m. contingent upon authorization. So, Ms. Hunt?
Yes, ma'am.
I'm going to continue your case to that date, July 22nd at 9 a.m., which means, of course, you will be continued on your bond with all continuing conditions.
Yes, ma'am.
Thank you. You are excused at this time. And
you're expressly no contact with the victims until trial.
No contact with the victims.
I have not had any contact with them.
All right. Thank you, Ms. Hunt. You are excused. I believe we've already excused Ms. Turner. Mr. Paul, I think we'll excuse you at this point.
Thank you, Judge.
You are welcome. And we've reset Mr. Miller for plea. Have we not, Missy? We've given him a date.
Yes.
So that concludes our Greenwood County portion of the trial docket. You confirm that, Missy? You are excused, Miss Gillette. Do you confirm that, Missy? You're welcome.
Yes, I do.
Very well. Then we will spend the rest of the docket focused on the Butler County portion. Did Mr. Patterson come back in a position ready to address the jail defendants? Let me know as soon as he is able to do that, please. Chase Miller, I believe you are excused if you're still with us. I saw Charles Miller, but I think he's with another agency. Charles Miller, are you with the Butler County Community Corrections?
Yes, I'm here for John McGee.
Okay.
He's been on probation with me.
Well, let me find him among the many here. Okay, that's a Darren Patterson case. Is that a pretrial conference, Jim?
I'm sorry, Your Honor. Could you repeat that?
Well, these are all supposed to be set for pretrial. McGee is just set for pretrial?
Yes.
Okay. All right. Well, let's, thank you, Mr. Miller. It looks like it might be a bit. Ms. Japan, let's take on your client. You said he was for plea, and that's Mr. Moore.
Correct, Your Honor.
Will be on the record now in 2024, BU 2024, TR 1913. Please announce appearances.
Jared here on behalf of the state.
Anna Yumpen, and appears with defendant Philip Moore.
And what announcements, Ms. Japan?
Your Honor, we will be entering a plea of no contest to the second offense. In addition, there was another DUI that had been transferred over from El Dorado that the county attorneys has declined to prosecute, so we'll just be entering the plea on this today.
Very well. What is the plea agreement?
We'll just go ahead and be entering a plea to the standard minimums.
Okay, so plea discharged and then standard minimum recommendations.
Correct.
Mr. Moore, where are you?
I'm here.
Mr. Moore, I've heard what your attorney said. How do you plead to driving under the influence of alcohol or drugs after a prior conviction?
No contest.
By pleading no contest, do you mean you don't want to admit the charge, but you don't want to deny it and take it to trial either?
Yes.
You understand that means you're giving up your right to a trial. There will be no trial. You'll most likely be found guilty and unable to appeal your conviction.
Yes, ma'am.
Is anyone making you enter this no contest plea today by any kinds of threats or promises?
No.
Very well. Mr. Regier, is it Mr. Regier or Mr. Sweeney on this one?
I am present for purposes of this case, Your Honor.
Mr. Regier, is the state ready to prepare or provide a stipulation of what the facts would be or a proposal of what the facts would be to support this plea?
If the court is prepared to hear it, Your Honor.
I am, thank you.
Your Honor, pursuant to the affidavit, paragraph 4 appears to refer to a stop occurring on July 17th, 2024 at approximately 10:34 in the evening. It appears to refer to a specific location on West Central, just past Denver Street in El Dorado, Butler County, Kansas. Things are saying that is well within Butler County limits, given this court jurisdiction. It would appear that the officer, where this case proceeded to trial, would testify that a white Chevy Tahoe was observed stopping in the right-hand lane. Further on in the affidavit, it would appear that the vehicle was observed hitting the curb for a second time. It would appear that pursuant to paragraph 7, the officer attempted to conduct standard field sobriety testing. However, it would appear that the defendant refused. Subsequently, after being taken into custody, the defendant was measured with a blood alcohol concentration of 0.173. That does appear to be well above the legal limit in this case, and the state's evidence would show the same. Additionally, the state would proffer, if the court is prepared to accept it, a journal entry of plea and sentencing in Butler County District Court case 2009 TR 4481. It would appear that pursuant to the same at a hearing on February 8th, 2010, the defendant pled guilty to 1 count of driving under the influence. The opening paragraph of the journal entry further indicates, quote, the defendant appears in person with appointed counsel Doyle E. White Jr.
The court finds the defendant has knowingly and voluntarily entered a no contest plea to driving under the influence of alcohol, a second conviction. The state has provided a factual basis to support that plea. The defendant is found guilty. Do we have an alcohol and drug evaluation for sentencing, Mr. Pond?
Your Honor, it was received. It was done back in March. I forwarded it over to the state previously.
Very well. Mr. Regier, can you send that to me without much delay?
One moment, Your Honor. Your Honor, I am not personally aware of any drug and alcohol evaluations. So would respectfully suggest if counsel for the defense can provide that to the state and to the court, this matter should be able to proceed fairly expeditiously.
Well, Ms. Japanin, we can either continue this to another day, although I think it was your intention to resolve it today, or we could put this further in the docket and let you resubmit that evaluation to prosecutor and to the court. what would be your preference?
Your Honor, I am going through my email. I am not seeing it here. I prefer to go to another day just so I know for sure that I have that.
All right, so let's see. Jen, are you setting my sentencings on these?
Yes, I am. Are you wanting this on a control docket?
That'd be fine. Monday morning?
Yes. I have July 28th.
How about July 29th? Did that work for the parties?
No objection from the state, Your Honor.
That's fine.
Very well, Mr. Moore, I'm going to continue your bond with all existing conditions plus the added condition that you and counsel reappear Monday, July 29th, 9 a.m. for sentencing. You must, before that date, sign any releases and get your alcohol and drug evaluation to your counsel so she in turn can get it to Mr. Regier and to the court for that sentencing as it is required by law.
Yes, Your Honor.
All right, thank you. Anything
Your Honor,
further?
just to clarify, that Monday's the 28th, Tuesday's the 29th, which,
Okay, I wrote down the 29th, but I think Jen said the 28th.
okay, all right, that's what I thought. I just wanted to confirm.
Okay, thank you for doing so.
And-
Mr. Moore, the 28th, Monday, July 28th.
And will that be by Zoom?
By Zoom, yes.
Perfect.
All right, thank
Thank
you.
you, ma'am.
Mr. Conlon
you.
and Mr. Moore are excused.
Thank you.
You're welcome. And Arnold was for dismissal, and Mr. Jensen, you're waiting to resolve your appearance today on Martinez, correct? And we were in recess on that. Mr. Regier, you were going to visit with some of your staff. Do you have any announcements back on the record in 24 CR 13, all parties as before?
Yes, Your Honor, if I may.
Please.
Your Honor, the state's understanding is that my office has been in contact with the victim as recently as within the last 2 weeks. So the state's understanding is that any lack of service of a subpoena insofar as the victim is concerned is a non-issue. However, the state is not prepared to proceed in this case absent the testimony of Officer Weekly. So for that particular reason, there does appear to be a witness issue and the state is requesting a continuance.
Do you know where your witness is, the officer? If I continue this, in other words, will you find him?
That would be the state's intention, Your Honor.
Well, I know it's your intention, but do you have any reason to believe you can find him? From what the response said on that subpoena, I'm questioning that.
Your Honor, based off my notes in the file, I believe the state will be in a position to proceed with the testimony of Officer Weekly if this court is prepared to grant a continuance in this matter. I would also note that this matter was previously set for pre-trial. However, it would appear that the court did revoke the defendant's court-appointed counsel upon statements of court-appointed counsel Darren Patterson at the time, and the matter was continued, and that and then the court had previously made findings that all prior continuances were assessed to the defendant for speedy trial purposes as of a misdemeanor control hearing on February 10th.
Well, we've had 9 hearings in this case, the first one being January 8th, 2024, which is quite troubling. Attorney Jensen did appear with the defendant 210. That appears to be the first time after he took the case, after the defendant retained him. All right, so the state needs a continuance. Mr. Jensen, your response to that request for continuance?
We remain for trial today, Your Honor.
Well, I am going to reluctantly grant the continuance because the defendant has had so many continuances of his own. He had a misdemeanor control 1, 2, 3, 4, 5, 6, 7. 7 misdemeanor controls. And I realize you weren't counsel of record at the time, but I'm going to grant over objection the continuance. But I will note that it is over objection of defense. But I anticipate it will be the only continuance granted to the defendant, particularly on these reasons. At this time, we need to reset that, and my next jury trial date will be October 19th pretrial with 21st and 23rd trial. Isn't that correct, Jen?
October 19th is a Sunday.
The next,
All right.
the pre-trial is September 29th with jury October 1st and 2nd.
Okay. September 29th, and your jury trial will be October
1st and 2nd.
Second. Okay, 1st and 2nd. I'll continue the bond, Mr. Martinez, but you are to continue with the existing conditions and reappear ready to go to pretrial September 29th. 9 a.m. we will begin. So be here by Zoom. Jury trial will be live in person beginning 9 a.m. October 1st and 2nd. Nothing further. Mr. Jensen and Mr. Martinez are excused.
Thank you, Your Honor.
Thank you.
You are welcome. Anyone else for plea? None of you could work out a disposition, or did you not consult?
Judge, I do have a number of cases ready for plea if you're ready to start taking those.
I am. In the meantime, I would urge breakout rooms for anybody that hasn't attempted to resolve your cases short of jury trial. James Watts, have you talked to the prosecutor about Neil Beeman?
I have not, Your Honor. I expect that one's going to proceed to trial.
Okay, is that tied to a felony, or is the felony resolved? Did someone tell me you resolved
The felony was dismissed some time ago, was transferred back to this court.
And Judge, if you recall, I have a Beeman case also. Mr. Watts has a Beeman case. Would it be all right to put the three, Mr. Regier and me and Mr. Watts, in a breakout room real quick, talk about those?
Let's go ahead and do that. That's the only one on Mr. Watts' docket, on the docket with Mr. Watts. Jan, would you please put the prosecutor, Mr. Regier, and the defense counsel, Darren Patterson and James Watts, in a breakout room on Beeman? And Attorney Weishman's case on caps has already been reset, correct, Jen?
Yes.
Okay. And that brings us to, how about, and the Fleece case also, well, are they here, or did we go ahead and journalize that, Miss Norris?
That one's been journalized and has already been taken care of. Your Honor, you just mentioned PAPS.
I don't know that I did, but I certainly will.
Well, you just were talking about Mr. Weishman's case?
Oh, yes. I'm sorry. Yes.
Was that PAPS?
Caps with a, yeah, caps with a C.
Caps. Oh, I'm sorry, because I just wanted to clarify.
Well, I think we have a PAPS on here too, so that was
we do.
And is that your case, Michael Paps? It's a Darren Patterson case, however.
No, Your Honor, it's actually Mr. Sweeney / Mr. Regier's. but it's also Darren Patterson case. So
Okay.
it's a possession of marijuana case. But yeah, I think without Darren, we can't proceed.
I think you're right. Do you have any, Miss Norris, that could proceed for plea or otherwise dismissal?
Your Honor, there are notes in several cases, but I don't think any of the ones left don't belong to either to Darren. I'm not sure if anybody else is represented by any other attorney.
Okay.
At this point.
I see what you're saying. Very well. We'll just wait till Mr. Patterson comes back, because yes, it looks like they are all his from here out. All right, I'm going to close my screen and my microphone for just a moment till they come back. Mr. Patterson, are there any announcements on this matter?
Your Honor, after discussions, we have initiated plea negotiations. Mr. Regier has stated he would consider those, but is needing additional time. I'm not sure how much time he is needing for that, though.
Well, Mr. Regier, how much time do you need?
Your Honor, hopefully it would not be a particularly long endeavor, but again, I was not aware that any prospective plea negotiations could be made in this case until approximately 30 seconds ago. So I will need the opportunity to consider both these matters together before I am in a position to respond.
Can that be accomplished today at some point in this docket if you're given enough time?
That would be the state's hope, Your Honor.
Very well. Do you need to take that time right now? And maybe I can use Mr. Patterson for some of these other defendants that are clients of his and another prosecutor?
Your Honor, if the court wishes to take both these matters up later on, perhaps towards the end of the docket, I don't think the state would have any objection.
All right. Do you need some time now, though?
If the court is prepared to grant it, I understand my colleague, Ms. Norris, and Mr. Sweeney will be called into other courtrooms momentarily before certain district court judges.
All right. Well, why don't you take what time available now, and I will see what I can accomplish with the other prosecutors before they have to leave to the district judges. How about the gentleman in jail? Mr. Patterson, are either of them ready to go?
Kyle Hughes, Your Honor, if we could do him, he's in custody.
All right, let's take up Mr. Hughes on the record in 2024 CR 513, State of Kansas versus Kyle David Hughes. Please announce appearances.
Amber Norris for the state.
Your Honor, Darren Patterson appearing on behalf of Kyle Hughes. Mr. Hughes does appear from the Butler County Jail. Judge, this is a case where my client is charged with theft and driving while suspended second. I have met with Mr. Hughes in jail. I've also reviewed basically everything going on with Mr. Hughes. He does have other Butler County cases that are set for jury trial pre-trials in July, as well as prelim in June. These are all felony cases. Judge, this is a case where I am asking the court to allow continuance of this jury trial to work on basically plea negotiations on the mixing it in with the felony cases, if that can be accomplished. Otherwise, this continuance would be at the speedy trial for purposes at the defense request. and would ask that it be set down for the October date for jury trial if we can't work anything out. But I think we probably could, Judge.
Do you know who the July jury trial is before, which judge?
I'll leave that to Miss Norris. I don't have that right in front of me. I do have down that it's July 1 pretrial, July 8 jury trial.
One moment, Your Honor.
Very well.
Judge, I believe that that's with Judge Hart. And Your Honor, we have been working towards resolving all of Mr. Hughes's cases. He's got, I think Mr. Patterson makes 3 attorneys and possibly, and I think at least 3 judges. So it's, we're still working on kind of coordinating the final plea, but I think that's going to happen.
What I'm wondering is if we could impose upon Judge Hart to maybe put this with the July jury trial.
Your Honor, the pretrial actually is on Tuesday, the 1st. I don't have any problem with that if Mr. Patterson doesn't.
I would think that would be all right with Judge Hart, so that I would contact his office and see if we could use the pretrial date, July 1st, to put this on there also.
He's generally pretty gracious and accommodating, and I hate to presume or take advantage of that, but if he would do that, I would like to continue this to the pretrial date of July 1st. If we think that that's reasonable to expect an agreement among the cases by then. Ms. Norris?
I do, Your Honor.
Okay. All right. Janet, well, let's tentatively put this on Judge Hart's docket, July 1st pretrial, and then his jury trial docket probably just his pretrial docket for plea if he's subject to that. If it goes to felony jury trial, or if you can't work out an agreement that includes this misdemeanor, then it will go on my October docket, Mr. Patterson.
Yes, Judge. And again, this is a continuous request on behalf of the defendant.
And if we note that for the record, it is at the request of the defendant. That being said, we'll be in recess. Mr. Hughes, you are excused and remanded to the custody of the sheriff on this case at this time. Thank you.
Judge, we also have Jack Nelson in custody.
Okay.
Ms. Zenda, if you could.
Good afternoon, Your Honor. Allie Zenda on behalf of the people. Your Honor, the people would waive any potential conflict between the honorable court and the office of the public defender. While the people believe there is no such conflict, people make this waiver in avoidance of all doubt.
All right, Ms. Pate.
Good afternoon, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe a conflict exists between this honorable court and our office, but if one were to arise, we would waive such a conflict.
The court, for its part, also does not believe there's a conflict either under the Michigan court rules or the cases decided there under. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Okay. Court does call the case of the People versus Demario Farrell.
Allie Zenda on behalf of the people, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Farrell, who stands to my right. Please state your name for the record, sir.
Demario Farrell. Thank you.
Thank you, Your Honor. As to the case, we respectfully request to set it for final settlement conference and then to address bond when appropriate.
Jury final settlement conference will be June 6, 2025, 9 a.m. Jury selection, if necessary, June 9th, 2025, 8:30. Both of those proceedings are in person. Esteban.
Thank you, Your Honor. It is my understanding that Mr. Farrell's bond is currently denied due to an alleged bond violation and then his subsequent failure to turn himself in on that warrant as ordered by the court back in 2023, I believe was the year. As to the bond violation, he does admit to that and is asking the court to consider releasing him pending his final settlement conference. He does state that he did leave the state of Michigan, where he was originally from, to go to Georgia during one of the prior bond violations. He has provided me with an updated address in Ypsilanti, Michigan, where he currently stays with a family friend. The complaining witness does not reside there. He is willing to go on tether or comply with any other terms as ordered by the court. He's asking for release today on a PR bond. My client states to me that he came into custody on the warrant during a traffic stop for lights, and to my understanding, no new charges stemmed from that police activity. To my understanding, his only current Washtenaw County matter is a license case. We do acknowledge that there is a hold out of Livonia, however. He does also have a potential job that he is currently in the onboarding process for in Wixom at Purin doing assembly of car exhausts. He does have a 4-year-old daughter, and he is now local to court. We are asking the court to consider his release pending the final settlement conference.
But he was almost 2 years?
Yes, Your Honor.
Response.
I would object to any modification of bond. First, he failed to appear back in April of 2023. At the time of that, there was a couple bond concerns in which he had gone to Georgia without permission, violating his bond, and the victim had also informed us he'd been contacting her since his release from jail. That didn't get a chance to get addressed because he failed to appear back in 2023. I also have concerns as to this case, and our office is going to be looking into is why it wasn't charged as a felony strangulation given the facts in the police report. And I just have concerns that he failed to appear back in 2023 and had to be picked up for this case to come back around. So I would object to any modification of bond at this time.
Anything else?
Just very briefly, Your Honor, the only thing I would state as to that is that Mr. Farrell came back to the Michigan area last month, he states to me. One of his reasons was he wanted to take care of this matter. That being said, he was picked up on a traffic stop. And I would just ask that he be released pending the final settlement conference or final settlement.
It doesn't necessarily make any sense. If he came back to take care of it, he could have turned himself in at any given point. He didn't do so. He had to be picked up.
I understand, Your Honor.
2 years later. Motion for bond reduction denied. Bond will continue as denied.
Thank you, Your Honor.
Thank you so much.
Court does call the case, People versus Stephen Watson.
Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Mr. Watson, who is approaching. Please state your name for the record, sir.
Stephen Watson.
Thank you, Your Honor. As to the case itself, we asked to set this for final settlement conference and then address bond when appropriate.
Go ahead.
Thank you, Your Honor. So I know Mr. Watson was last in front of Your Honor for a PCC, or it might have been a preliminary examination, my apologies. And Your Honor said he may consider a bond reduction if there was a plan in place as to treatment. I did reach out to the CCOP program and emailed back and forth a little bit with Mr. Brown. And he states to me that in order to be assessed, they would need either a court order for referral. So my first request is if the court would consider signing an order for him to be assessed for the CCOP outpatient program in order to continue treatment, if the court would consider signing such an order.
I don't have a problem doing it.
Thank you, Your Honor. And I did state to Mr. Watson that it would be unlikely that he would be released prior to that assessment, but I would like to make a brief argument for that if the court would allow. So, Your Honor, I have spoken directly with Mr. Watson's mother last week. She does state to me that she really would like her son to be out. She actually currently resides in Detroit and has been involved in a building fire and then has a foot injury. All that being said, she told me that Mr. Watson is there at least once every other week, visiting her, helping her with her medical needs, and is hoping that he can be released and goes home. My client, however, also resides in Ypsilanti, away from the complaining witness. He had full-time work and he has spoken to a supervisor since his time in incarceration, but if he is here too much longer in jail, he may lose that employment. He's willing to do a tether, and he has also states to me he is willing to test every single day. I do understand the court may be wanting to wait for that CCOP assessment. However, I would be asking if the court would consider his release pending the assessment as well as the final settlement conference. He does have a lot of family support. I do not believe Mr. Watson would be a flight risk or a danger to the community, and I would ask that he be released today as well, pending that assessment.
All right, I don't need a response. I'm not going to do that. I think with Mr. Watson, he was quite frankly frank with me in terms of what was needed previously. And until I see that assessment, I'm not going to change anything on that.
Understood, Your Honor. Thank you. And I will provide that order to the court today.
Well, I'm going to order him to
CCOP
outpatient program.
Understood, Your Honor.
Will they do the assessment on that order? Did they need something?
They will do the assessment on that order, to my understanding.
And I'm signing.
Oh, perfect.
I'll speed this along.
Thank you so much.
Assessment, see where he is, and then if it needs to be brought back for the court, contact Ms. Wyatt, and we can try to figure out how we can get that done.
Absolutely. Thank you, Your Honor.
Appreciate it. Oh, the dates, his jury final settlement conference, June 6th at 9 a.m. Jury selection if necessary, June 9th, 2025, 8:30.
Thank you, Your Honor.
Okay. All right, thank you. Court stands in recess.
Let's see. Your Honor, based off of my review of my notes, I'm unable to state that conclusively one way or another. What I would tell the court is I have been in communication with my colleague regarding this case, and I believe counsel for the defense has accurately summarized the current state of this matter.
Well, for now, we'll leave this on for jury trial. I'm quite stunned that we're set for jury trial in 2 days and the state hasn't talked to the alleged victim. But for now, Mr. Grimes, unless you want to stay on the docket until the end to see if they can call the victim and do whatever this talk is they need to have, I'll have to set this over to the date of the jury trial, which is Wednesday.
Okay.
Mr. Regier, can your office try to get a hold of the victim during this docket?
I will put in the note in the file, Your Honor.
It doesn't sound to me like you were ready or prepared if you haven't talked to the complaining witness. But in any event, we're going to go into a temporary recess, Mr. Grimes. On the record in 2020 BU 2024 CR 485, State of Kansas versus Crystal Dawn Haynes, Jared Regier for the state, Darren Patterson for the defendant. Just mute, please, Mr. Grimes. Crystal Dawn Haynes.
Judge, I've not seen her on here today, and I'm also not sure why she's not. It was a case that was going to be announced for trial. So I don't want to ask for continuance either because she did want a trial. So I'm not sure what the court would want to do, whether the court would allow additional time to find her or what the court wanted to do.
I'll give you time to find her until the end of this docket. We'll now be on the record in 2024 TR 2287, 2024 TR 2728, State of Kansas versus Candace Kathleen Hushaw. Jared Regier for the state, Darren Patterson for the defendant. Ms. Hushaw, if you'll join us, I'll give you credit for being here. Please start your audio and video. Thank you. Mr. Patterson, any announcements?
Yes, Your Honor, this is a case where we have worked out certain plea negotiations. I would announce at this time pursuant to those plea negotiations, Ms. Hushaw will, in case number 24 TR 2287, enter a plea of guilty to driving while suspended after previous conviction for driving while suspended, count 1, as well as plead guilty to count 2, 80 and a 65. States agreed to dismiss 24 TR 2728 in return.
Mr. Regier, that is your plea agreement?
Yes, Your Honor. What I would tell the court is that pursuant to the amended information filed on October 20th, 2024, in 24 TR 2287, it would appear that count 1 is listed as speeding and count 2 is driving while suspended, a Class A misdemeanor. However, as to the issue of dismissing the other case in exchange for a plea is charged to counts 1 and 2, that is the state's understanding.
All right. Ms. Hushaw, how do you plead to count 1, speeding 80 in a 65 mile per hour zone?
Guilty.
And how do you plead in that same case? Okay, somebody needs to mute. I'm picking up some interference there. And in that same case, how do you plead to count 2, driving while suspended after a prior conviction for the same?
Guilty.
By pleading guilty, you're admitting that you were speeding 80 in a 65 and driving while your license was suspended after a prior conviction for driving while suspended?
Yes, ma'am.
And are you admitting this because you believe you are in fact guilty of those 2 charges?
Yes, ma'am.
Is anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, ma'am.
Do you understand you're giving up your right to trial, including the jury trials we had scheduled for Wednesday?
Yes, ma'am.
And that you'll be found guilty and unable to appeal your conviction. Do you understand that?
Yes, ma'am.
Okay. And were you driving in Butler County as alleged on August 28th to 24?
Yes.
Do you remember what highway you were on?
The back road between Winfield and Rock. Well, it was between Winfield and Augusta, so I was on my way to work.
So if on the citation, the officer, which would be Master Trooper Brian Grunder, said it was on Highway 77 at mile marker 36 north in Butler County, would you agree with that or take issue with it?
No, I would agree with that.
You'd agree with that? Very well. And that was a 65 posted and you were driving 80. Is that what you're telling me?
Yes, ma'am.
All right. And you had that prior conviction for driving while suspended.
Yes, ma'am.
All right. I accept your plea in 2287 and find you guilty. I do, pursuant to your plea agreement, dismiss with prejudice case number 2024 TR 2728. Those case numbers are quite similar, but you have been found guilty in 24 TR 2287. Recommendations for sentencing, Mr. Regier.
Yes, Your Honor. Pursuant to plea negotiations in 24 TR 2287, the state is recommending the scheduled fine and court costs for the speeding for the driving while suspended. The state is recommending a $100 fine, court costs deferred to the court on the issue of attorney's fees. The state is further recommending a year of reporting probation, subject to a $60 probation fee and a 6-month underlying sentence. The state is further prepared to recommend a 10-day house arrest in lieu of the 5 days in jail. Also, although I understand this was not specifically discussed during the context of plea negotiations, it would appear that at the first hearing in this case on December 4th, 2024, the court did issue certain orders concerning booking and bond. I do have an affidavit from the jail that would appear to indicate that as of January 17th, 2025, the defendant failed to report to the Butler County Detention Facility as directed by the court to be processed and released. The state does acknowledge that there have been at least one recent hearing since the date of that, most recently on March 31st, 2025. However, the state has not been able to confirm that there have been any appearance bonds executed in this case.
Mr. Patterson.
Your Honor, as far as sentencing, we'd ask court to adopt the recommendations. We would also ask court to allow the 10 days house arrest with work release. As far as the bond issue, I haven't researched that. And also, I don't know that I was present when it was ordered, but so I don't have any information on that part of it.
Ms. Hushaw, before I even proceed to your sentencing, why should I not find you in contempt in both these cases for violating my orders to go out and get your picture and prints and bond? Why should I not have you serve jail time and pay a fine on that before we get to your sentencing?
I thought I had went out there. I went out there and got fingerprinted for something. I thought it was this case, but this was the only 2 cases that I know of that I have in Butler County. And I went to El Dorado once just to get my fingerprints done, but other than that, I wasn't aware I needed to go again.
Is CLW, Jen, a county, or is that Clearwater, the city? If you know. Do we have a county CLW?
Your Honor, I do not know.
Yeah. All right. Well, Ms. Hushaw, it looks like you have something pending in another jurisdiction and yet another jurisdiction and in Butler County. And you have a long, long history of traffic violations. So it is possible that maybe you mixed up getting your fingers and prints taken in one of those other jurisdictions. Court security, are you available?
Yes, Your Honor.
Do you have any way of finding out fairly quickly if she had any picture prints taken in either of these cases?
And Your Honor,
Mr. Regier?
one thing I might add for clarification, in the 24 TR 2728 case, I am showing an appearance bond in the amount of $2,500 on recognizance. But again, I have been unable to confirm whether or not any appearance bonds have been successfully executed in the 2287 case. And that it would appear that the jail affidavit I had previously referred to on the record is in reference to that particular case.
All right. So it sounds like you went out maybe on one but not 2. Deputy?
Our control is out to lunch, but I'm trying to figure it out.
And,
okay.
And I just would point out, Judge, that doesn't make a lot of sense to me. That the one that I'm told now that she has a bond in happened in August. And the one that she doesn't have a bond in happened in August. The one she does have a bond happened in October. how's it she got a bond in the later one and not the earlier one? It seems like when she go out to jail, they'd do both of them at once.
Unless, I don't know.
And Your
I
Honor,
don't know how they do that. Mr. Regier?
what I would tell the court is that the amended information in the 2728 case does appear to refer to an alleged occurrence date on October 10th, 2024. It would appear that the first appearance hearing on that case was in January of 2025. In the 2287 case, the amended information does appear to refer to an October 28th, 2024 occurrence date on the information. However, I'm not, and it does appear that the first appearance in that case occurred in December of 2024. I'm not sure if that helps the court or not in this.
Well, I think it answers Mr. Patterson's question. The one that she got first, she appeared on later for whatever reason that happened. So, well, I don't know, Ms. Hushaw, about giving you probation if I can't trust you to comply with my basic orders. I don't know that that makes you a good probation candidate.
Is there not any other time I'm able to go out there? I can go
That's
out
not
there
the
today.
point. That's not the point. The point is you didn't do what I told you to do when I told you to do it. Let's see what court security says, if they can get us an answer in a timely fashion.
I honestly thought that when I went out there, it was taking care of both of them. That's
Well,
my mistake.
You hadn't even been to court on the one before you went out. Deputy?
10-4.
All right, Deputy, what did you find out on that warrant?
She was
24?
processed in January. I'm not sure which case yet, but she was processed in January of this year.
And Judge, again, that goes to my point. She would have had first appearances on both cases. Why didn't they do it both at one time? I mean.
All right, well, here's what I'm going to do, Ms. Hushaw. I'm going to follow the recommendations, and I'm going to order that you go out there as a condition of your probation and get both of them squared away. And if you don't, you'll be in violation of probation. That probation can be revoked, and you can serve any sentence that I impose herein. So let's proceed with sentencing in 24 TR 2287 for speeding 65 and an 80. I impose the scheduled fine of $75. Because this is an infraction, there will be no jail time. On count 2, driving while suspended after a prior conviction for driving while suspended. Your fine will be $100. Your sentence will be 6 months in jail. Where do you work?
I'm an assistant manager at the Wendy's in Derby.
All right. You will be ordered to pay $250 of your court-appointed attorney fees. You will be ordered to pay $108 court costs. You'll be ordered to pay $60 probation supervision fee. Your controlling sentence is 6 months, but if you don't want to serve that, you will need to successfully comply with the reporting probation I'm about to give you. All standard conditions will apply, and they will give those to you. You must call probation as soon as this hearing is over, although they very well may be at lunch, as it is now 12:11 p.m. If you do not get an answer, leave a message and call again after lunch. It is your responsibility to call probation. It is not their responsibility to chase you around and send you letters and call. If you miss your appointment, that's on you. It's not enough to say, well, I tried to call them back and they never returned my call. It is on you that you must appear when they tell you to. I'm telling you to call them, and here is the number: 316-322-4153. Call them today. Your probation includes that you complete the mandatory 5 days in jail. Are you wanting to do that in 10 days as house arrest instead?
Yes, ma'am.
I will give you 10 days house arrest, but you must have the electronic monitoring on and begin that house arrest within 7 days of today. You are not to leave your house for any reason except to go to work and come straight home. Don't stop and get a Coke. You will have that bracelet on, that ankle monitor. Mr. Regier, anything else I need to address other than dismissing the other case as part of the plea agreement?
Your Honor, if I misheard, I apologize. Is the court ordering that the house arrest, subject to electronic monitoring and work release commence within 7 days of sentencing?
Yes.
And Your Honor, is the court setting any, or rather is the court making any orders concerning the length of the reporting probationary period and the manner in which the case is to be paid?
The probation will be for 12 months, starting today. The money owed must be paid at the rate of 1/12 per month until paid, and the first payment will be due on June 19th, 2025. 1/12 will be due on the 19th of each month thereafter, again until paid in full. Anything else, Mr. Regier?
Just one final point, Your Honor. Is the state's understanding correct that notwithstanding the plea agreement which contemplates the dismissal of 2728, is the court ordering booking and processing in both cases for purposes of finalizing the journal entry?
The court is ordering.
Judge, looks like court security might have some information.
Deputy?
Your Honor, looks like she was processed on the 2728 case, but she was not on the 2287 case. So I'd need a bond amount, and I'll schedule her to go out and get that done.
She has been convicted, and it is being ordered as a condition of her probation to get out there and get that done, so she won't need a bond. But you need to, I'm ordering you as a condition of your probation. He's going to give you an appointment, court security is. Keep that appointment, or you're going to be in violation of your probation, and you can get your probation revoked.
Yes, ma'am.
All right. Look, anything else from either counsel, Mr. Patterson?
Nothing further.
Anything further, Mr. Regier?
No, Your Honor.
All right, Ms. Hushop, go into the breakout room with the officer, get your date.
Honor,
Yes, sir.
I don't have another person here, so if I could just give her a date right now, that'd be great.
Go ahead.
Okay, Ms. Hushaw, need you to go out there on Thursday. You want morning or afternoon?
Thursday should be afternoon. Sorry.
Afternoon?
Actually, if we could do morning though, that would be great.
Okay. Thursday at 10 o'clock.
Okay, 10 a.m.
Go to the jail and just tell them you need to be fingerprinted and pictured because you took a plea. You don't need a bond.
Okay.
And I'll make sure I let them know.
Tell her that address, please.
It is 701 Stone Road in El Dorado. 67042.
If you get off the turnpike and head straight down the 254 that becomes Central and keep going past El Dorado, it'll take you right there to the jail on Stone Road. You'll see the sign, right? If you go to the prison, you've gone too far.
Okay.
But you're going to call probation and get that set up as well. If they want to transfer that to your home county, do you live in Cedric? Okay. Transfer that county, they certainly can do that. But Those are the orders of the this time, and if there's nothing further, we'll be in recess.
Okay, thank you.
You're welcome. We'll now be on the record in BU 2024 TR 1551, State of Kansas versus Jennifer Lynn Jester. Jared Regier for the state, Darren Patterson for the defendant. Jennifer Jester.
Your Honor, this is a case where she is not on here. I don't have an explanation of why she's not on here, and we do not have a current phone number for her. The one we had is not in service, so I don't have an explanation of why she's not here.
Charge is driving while suspended after prior conviction. Recommendations, Mr. Regier.
Your Honor, this is a case where it would appear that a $2,000 professional surety bond was executed in this matter. Based off my notes, I am not showing, it would appear that there was an attempt at service that was unsuccessful back in August of 2024. However, I'm not showing that I'm not sure if the court considers that a failure to appear, but at least after that, there have been no failures to appear. Nevertheless, the state does note for the record that this matter is scheduled for a jury trial, as the state understands. Additionally, it is the state's understanding that at least one subpoena was issued and the state's witness was served. For that reason, the state is recommending a bench warrant bond forfeiture, no bond hold.
When someone sets a jury trial and then they fail to appear for pretrial or jury trial, this court believes no bond hold is appropriate. So I'm issuing a bond forfeiture, a bench warrant, and new bond will be withheld until she sees the judge. So no bond hold. Will be on the record in 2024 TR 2141, State of Kansas versus Charles Richard Kellogg. Jared Regier for the state, Darren Patterson for the defendant, who appears in person on one count of DUI. Mr. Patterson.
Thank you, Judge. I would announce at this time, pursuant to plea negotiations, Mr. Kellogg will enter a plea of no contest to count one, the only charge, driving under the influence of alcohol, class B, non-personal misdemeanor.
Mr. Kellogg, how do you plead to driving under the influence of alcohol or drugs?
No contest, Your Honor.
By pleading no contest, do you mean you're not admitting the charge, but you're not going to deny it and take it to trial?
Yes, Your Honor.
You understand you'll still be found guilty and unable to appeal your conviction?
Yes, Your Honor.
Anyone making you enter this plea today?
No, Your Honor.
All right, Mr. Regier, have you a factual basis for this charge?
Yes, Your Honor. Paragraph 4 of the affidavit does appear to refer to an encounter occurring on June 22nd, 2024. Forgive me.
Someone needs to mute.
The encounter appears to involve a vehicle traveling westbound on K254 at mile marker 22. State's understanding is that is within Butler County, Kansas, specifically between Towanda and El Dorado city limits, which the state respectfully submits will give this court jurisdiction. It would appear that upon observing signs of impairment, the officer conducted standard field sobriety testing. Subsequently, it would appear that blood alcohol concentration was measured in excess of the legal limit, specifically 0.147, according to paragraph 17 of the affidavit.
I find the defendant has knowingly and voluntarily entered a no contest plea and the state has provided the factual basis. I find the defendant guilty. I would proceed to sentencing. We do have an alcohol and drug evaluation by Assessor Nancy Chavez. Recommendations being that the defendant complete a 48-hour alcohol substance abuse program and abstain from alcohol. Mr. Regier, recommendations.
One moment, Your Honor. Forgive me, Your Honor. The state is recommending at this time pursuant to plea negotiations, the statutory minimum fine of for a Class B DUI of $750, court cost that the court make a determination on the issue of attorney's fees. The state is further recommending that the court impose an underlying sentence of 6 months, the maximum for a Class B misdemeanor, subject to a year of reporting probation, subject to all standard conditions, including a $6 probation fee, that the defendant be ordered to complete a DUI victim panel, comply with all recommendations of the drug and alcohol evaluation, and any other orders of the court may deem appropriate.
Mr. Patterson?
Judge, I am retained in this case. Nothing further.
Very well. At this time, Mr. Kellogg, I will sentence you to 6 months in the county jail and order a fine of $750. I will also assess 108 court costs, $60 supervision fee, and your probation will be for 1 year. Your probation will include all standard conditions and special conditions, the DUI victim panel, completion of the alcohol and substance abuse program, 48-hour program, and that you sign all releases between court services and any other entities that need to be signed in order to give probation access into conditions of probation. You will need to pay at the rate of 1/12 per month, at least 1/12. Each payment will be due on the 19th of the month, with the first one being due June 19th, 2025. Any questions about this, Mr. Kellogg?
No, Your Honor. I'm not sure if it matters, but I was going eastbound. They said I was going westbound on 254.
Okay.
I don't know if that
Okay.
matters.
Is it still within our jurisdiction, Mr. Regier, I trust?
Yes, ma'am.
That would be the state's evidence for this case to proceed to trial, Your Honor.
Thank you. All right. Call your probation officer immediately, 316-322-4153. If they're at lunch, leave a message and call again today until you get them. Mr. Regier or Mr. Patterson, anything further?
Nothing further, Judge.
Mr. Regier, anything further?
If the court is not making any orders about the manner in which this case is to be repaid in full, the state has nothing further, Your Honor.
I believe I said 1/12 per month, first payment due June 19th and on the 19th of each month thereafter.
Very good, Your Honor.
Thank you. You may go call your probation officer, Mr. Kellogg. Will now be on the record in BU 2024 TR 1197, State of Kansas versus Jason Paul Leach. Jared Regier for the state, Darren Patterson for the defendant. Mr.
Judge,
Leach.
I have not seen him on here. I would tell the court that we have been attempting to contact him, but have been unsuccessful. I have no explanation of why he's not here today.
The court does issue a bond forfeiture, a bench warrant, and no bond hold. We will now be on the record in Lawless, case number 2024 TR 2098, State of Kansas versus George Leonard Lawless, Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Mr. Regier, Mr. Patterson, I guess, Mr. Patterson, it's back to you.
Judge, this is a case where I need about 2 minutes in a breakout room with Mr. Lawless, and then I believe it's going to be for plea.
Very well. Jen, if you'd please put Mr. Lawless and Mr. Patterson in a breakout room. Mr. Lawless, look for that invitation on your screen.
Yes, ma'am.
And then click on it. Thank you.
Your Honor,
Yes,
may I go off mic and off camera very briefly?
yes, absolutely.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Oh, Mr. Regier will be back with us shortly.
My apologies, Your Honor.
No apologies necessary. Back on the record in 2024 TR 2098, State versus George Leonard Tullis. Parties as before. Mr. Patterson.
Your Honor, if I may inquire first, it appears from my file that what we're looking at is an NTA versus long form. Is that correct?
The citation and notice to appear were filed August 13th of 2024, and I do not see any other documents, charging documents after that, Mr. Patterson.
Thank you, Judge. Pursuant to plea negotiations, I would make the following announcement that my client will be entering a plea of guilty to count 1, which is driving 106 and a 75. Further, as to count 2, it doesn't list out subparagraphs, but what is agreed to is that specifically it would be a charge of KSA 8-1017, subparagraph A, subparagraph 1. And on that charge, and which is kind of an important modification, I don't know if there needs to be an amended information or something, but on that amended charge, my client is going to enter plea of guilty.
And that's circumvention of ignition interlock. Oh gosh, let me. All right, can you tell me those subs again, please, Mr. Patterson? Make sure I get those right.
Yes, Your Honor. Subparagraph 8-1017, little a, and then 1.
A1. All right, is that your amendment, Mr. Regier?
That is the state's contemplated amendment as the state understands the terms of the plea negotiation reached between counsel for the defense and my office, Your Honor.
And to clarify, that is tampering with an ignition interlock device, circumventing it, or rendering it inaccurate or inoperative, Mr. Patterson?
Yes, Your Honor.
Mr. Regier?
I believe that is an accurate quotation of subsection A1 of KSA 8-1017, Your Honor.
All right, and how does your client intend to plead again, Mr. Patterson?
Guilty, Your Honor.
Mr. Lawless, how do you plead then to speeding 106 miles per hour in a 75 mile per hour zone?
I plead guilty.
And how do you plead to the amended charge of KSA 8-1017, parenthesis little a, close parent, parenthesis 4, close parent, which, I'm sorry, 1, which is to tamper with an ignition interlock device, circumventing it or rendering it inaccurate or inoperative?
I plead guilty.
By pleading guilty, you're admitting these two charges, that you did speed at 106 and that you did in some way tamper with your ignition interlock?
Yes, ma'am.
All right. And did this happen in Butler County, Kansas, on the Kansas Turnpike, commonly known as, or officially known as I-35 at mile marker 86 South?
Yes, ma'am.
On August 9th of 2024, was that the right day this happened?
Yes, ma'am. I believe so.
And the speed zone there is 75. I can take judicial notice of that, but do you agree it was that speed on that day? That was the speed
Yes,
limit.
ma'am. Yes, ma'am.
Is anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, ma'am.
And you understand you're giving up your right to a trial? You'll be found guilty and unable to appeal your conviction?
Yes, ma'am.
And I do find that you freely and voluntarily entered your pleas today, and that you have provided a factual basis to support them. So I do find you guilty of the charges 1 and 2. Mr. Regier, have you any recommendations for sentencing?
Yes, Your Honor. Pursuant to plea negotiations for the speeding, the state is prepared to recommend the scheduled fine and court costs, as well as for the court to make a determination on the issue of attorney's fees if counsel for the defense is appointed in this case. For count 2, the circumvention of ignition airlock charge, the state would be recommending a $100 fine, subject to 120 days underlying sentence and a year of non-reporting probation.
Mr. Patterson, anything further?
Judge, I am retained on this case. Nothing further.
Mr. Lawless, at this time, on count 1, your fine is $108. On count 2, I'm sorry, strike that. Your fine on count 1 is $210. That's the scheduled fine. On count 2, your fine is $100. You're also assessed $108 court costs. Your sentence will be 120 days suspended so long as you successfully complete a 1-year non-reporting probation. You don't have to see a probation officer, but you do have to follow the probation orders I'm about to give you. 1, you are to violate no laws of any kind during this 1 year. 2, you're to pay the total of $418. Can you, oh, wait a minute, maybe that's, no, that's right. Can you pay that within 60 days, or do you need a little more time?
60 days, ma'am.
And pay that within 60 days, don't violate any laws, and you will have satisfied this probation at the end of 1 year. If you want to know how to pay that online or any other way to pay it, please call the clerk of the district court in Butler County at 316-322-4370. 4370.
Ma'am, the number broke up. I didn't get, all I got was 322.
All right. Call the Butler County Clerk of the District Court at 316-322-4370.
Last number.
0
70.
4370.
70. Okay. That's
Correct.
322-4370.
That is correct, yes. Anything else from anyone?
Not on this matter, Judge.
Okay, if there's nothing else, Mr. Lawless, you are excused from today's proceedings.
Thank you.
You are welcome.
Bye-bye.
Bye-bye. We'll now be on the record in 2024, BU 2024, CR 503, State of Kansas versus John Marshall Shoemaker. Judge Regier for the state. Is John Marshall Shoemaker here?
Yes, I'm here.
The gentleman marked John McGee, M-A-G-E-E. You are also John Marshall Shoemaker.
Yes, ma'am.
The defendant appears in person and with counsel Darren Patterson. Mr. Patterson?
Judge, this is a case that will end up going to trial. I can tell the court that I had originally discussed with the county attorney's office that I would be requesting a continuance because I'm missing some witnesses. To explain that a little bit further, there are 2 eyewitnesses that were not subpoenaed by the state. I have now contacted and have clarification on one of them that they can be there on Wednesday and be prepared to testify. The other one, though, did have a child. The birth was last Thursday. And I'm a little bit tentative on knowing how to press somebody who's just given birth to be at court. So I have to continue with what I originally had requested, or that I told the prosecutor I'd request, which was a continuance to the next court date, so I can make sure and have both eyewitnesses, and these are actual eyewitnesses, Your Honor, present to testify.
All right, well, before I grant a continuance, this may be the case that needs to go. I'm going to withhold ruling on the request for continuance and have Mr. Shoemaker McGay stay with us for a bit till we get to the end of the docket.
Yes.
So we'll be in recess. We'll now be on the record in 2024 TR 234, State of Kansas versus Daniel Moriarty. Jared Regier for the state, Darren Patterson for the defendant, Daniel Moriarty, who also appears in person. If you'd start your audio and video, thank you, sir. Mr. Patterson.
Thank you, Judge. When announced this time pursuant to plea negotiation, the state has agreed to amend the charge to that of KSA 8235, no valid driver's license. To that amended charge, Mr. Moriarty will enter plea of guilty.
And do you so amend, Mr. Regier?
The state would so amend, Your Honor.
Very well. Mr. Moriarty, how do you plead to the amended charge of driving without a license in Butler County, Kansas on October 25th of 2023?
Guilty, Your Honor.
By pleading guilty, you're admitting that you drove without a license in Butler County on that day?
Yes, Your Honor.
And did you do that driving on Wednesday, October 25th of 23, as the officer alleges?
Yes, Your Honor.
And were you on Highway 54 at Southwest Santa Fe Loop Road, Augusta, Kansas, in Butler County?
That's correct, Your Honor.
And you didn't have a driver's license?
That's correct, Your Honor.
Anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, Your Honor.
You understand you're giving up your right to trial, including the jury trial we're set for, and that you'll be found guilty and unable to appeal your conviction?
I do, Your Honor.
All right, I accept your plea as freely and knowingly given, and a factual basis exists to support it. Finding the defendant guilty, I would inquire of sentencing recommendations, Mr. Regier.
Yes, Your Honor. Pursuant to plea negotiations, the state is recommending a $100 fine, that the court make a determination on the appropriate amount of court costs, as well as a $60 probation fee. The state is further recommending that the court make an appropriate determination on the issue of attorney's fees, as well as impose a 12-month reporting probationary period subject to a 6-month underlying sentence, the maximum sentence allowed by law for a Class B misdemeanor.
Mr. Patterson, anything further?
Nothing further, Judge.
Mr. Moriarty, where do you work?
I work at DHL Logistics for Case New Holland.
Okay. At this time, I am ordering you to pay a fine of $100, also assessing $250.
And Judge, I'm appointed, I'm sorry, I'm retained in this case.
Oh, you're retained. Okay. You did say that. I am ordering a fine of $100 and assessing 108 court costs and $60 probation supervision fee. Your sentence will be for 6 months. That will be suspended so long as you comply with your 12-month non-reporting probation. You have but two conditions of probation. One, violate no laws during this 12 months and pay the total of $268. Can you do that within 30 days, sir?
I will have you guys paid on Friday.
And
Very
Your Honor,
well.
and Your Honor,
Mr. Regier?
forgive my interjection. If the court is assessing a $6 probation fee, is that a 12-month reporting probation? That was the state's understanding of the plea deal negotiated in this matter.
You're recommending reporting probation, Mr. Regier?
That was contemplated by the plea agreement reached between the state and the defense, as I understand it, Your Honor.
All right. Well, I will follow the plea agreement, so you will have to report as directed. Contact probation at 316-322-4153. Call them as soon as this hearing is over. And if you don't get them, leave a number and call after lunch. But again, it is $100 fines, 100 court costs, $60 supervision fee. It is a 6-month sentence. It is still suspended, but you will have to report to probation as directed. Anything further?
Judge, the only additional item is that talking with Mr. Moriarty this morning, he was concerned about making sure probation knew that he had a pre-planned trip already to Texas in July, I believe it was. I told him as long as he speaks with his probation officer about that, there shouldn't be a problem with that. I just wanted to bring it up since Mr. Moriarty was concerned about it.
The court is granting you permission, Mr. Moriarty, to take that trip, but you do need to get it approved by court services before
Certainly,
you
Your
go.
Honor.
All right.
Certainly.
All right. Nothing further. You are excused at this time, sir.
Thank you, Your Honor.
You're welcome. We'll now be on the record in PAPS, that is BU 2024 CR 431, State of Kansas versus Michael Lynn Papps, Jared Regier for the state, Darren Patterson for the defendant. Michael Papps, who also appears in person. Mr. Papps, start your audio and video, please. Thank you, Mr. Papps. Mr. Regier, I'm sorry, Mr. Patterson.
Your Honor, pursuant to negotiations, I would announce this time, Mr. Papps will be entering a plea of no contest to count 1, possession of marijuana. States agreed to dismiss count 2, possession of drug paraphernalia.
That is your agreement, Mr. Regier?
That is the state's understanding, Your Honor.
How do you plead, Mr. Papps, to count 1, possession of marijuana?
No contest.
By pleading no contest, you're not admitting the charge, but you don't want to deny it and take it to trial either?
Correct.
Anyone making you enter this plea today by any threats or promises other than the plea agreement?
No, ma'am.
And you understand with this plea, you're giving up your right to trial and will be found guilty and cannot appeal your conviction?
Yes, ma'am.
Very well, Mr. Regier, factual basis.
Yes, Your Honor. Pursuant to the amended affidavit in this case, paragraph 4 appears to refer to an encounter occurring on May 1st, 2024 in the 19,000 block of Southwest Butler Road, Butler County, Kansas, involving a 2008 Toyota Camry. It would appear that a traffic stop was conducted by law enforcement the defendant was located as an individual occupying the vehicle. Subsequently, pursuant to paragraph 12, it would appear that law enforcement conducted a search of the defendant, and inside the defendant's right front pocket, law enforcement discovered a vape cartridge containing a fluid consistent with THC juice. which was later subject to field testing. That's quoting directly from paragraph 12 of the affidavit.
And field testing confirmed the presence of marijuana.
Your Honor, were this case to proceed to trial, the state's evidence would show the same.
Very well. Count 2 is dismissed. The defendant is found guilty of count 1, possession of marijuana. Mr. Regier, recommendations for sentencing.
Yes, Your Honor. At this time, the state is not recommending a fine. However, the state is recommending the imposition of court costs and a probation fee, and for the court to determine attorney fees. The state is further recommending on the sole count remaining before the court an underlying sentence of 120 days, subject to a 6 months reporting probation, and that the defendant be ordered to complete a drug and alcohol evaluation and follow all recommendations. I further do not know whether or not this final issue was discussed during the context of plea negotiations. However, this does appear to be a case where KBI restitution applies.
Anything further, Mr. Patterson?
Judge, I am court appointed in this case. I would tell the court I am aware of the KBI report that the drugs were further tested and acknowledge that there is a fee for that. Nothing further.
Thank you. Mr. Paps, where do you work?
I'm currently unemployed.
When did you last work?
It was about 2 months ago.
And what did you do at that time? What kind of work?
I was working for a construction company called Savvy Builders.
And why do you no longer have that employment?
Due to attendance.
Attendance?
Yes,
Are
ma'am.
you looking for work? Are you planning to have work in the near future?
I just need to get transportation and then I can get that job back.
And who's supporting you these past 2 months?
My wife.
At this time, you are ordered to pay the KBI $400. There will be no fine. There will be $158 court costs. There will be $60 probation supervision, and I am imposing $250 attorney fees because I believe you can work. You just need to do so. I will grant you a 6-month controlling sentence that will be suspended, provided you I'm sorry, I strike that. I am giving you a 120-day jail sentence that will be suspended, provided you successfully complete reporting probation. Mr. Regier, was the plea agreement that be for 6 months?
That is the state's understanding, Your Honor.
Ma'am,
Yes.
sorry. I just wanted to let it be known that I currently live in Wichita. That transportation would be really hard for me to get back and forth.
Well, the alternative is to have you serve the 120 days in jail. You want to do that?
I mean, I'd rather not. I'll try my hardest to get there. I mean, I'll have to reach out to some, like my mom and whatnot, but.
Well, how do you get to work? Oh, you said you got to get someone to take you?
Right.
I'm going to make this a 12-month reporting probation because I just don't foresee you getting everything done in 6 months. I am ordering that you find employment and maintain it. I am ordering all other standard conditions. You are ordered to get a drug and alcohol evaluation and comply with it. You are to call and schedule that evaluation within the next 14 days. You are to pay a 12th of the amount owed, which includes $400 KBI, 158 $158 court fees, $60 probation supervision fee, and $250 attorney fees. pay the rate of 1/12 per month, 1/12 due on the 19th of each month. First payment due June 19th, 2023. Call the probation office immediately after court. Are you ready to write it down?
Yeah. Go ahead.
I'm just curious, did you hear me tell everyone to get a pencil and paper a while ago?
My wife has her phone. She has it right now.
So you did hear me?
Yes, ma'am.
All right. Call the probation department at 316-320-4153.
Yes, ma'am.
Call them immediately after court. If they don't take your call the first time, leave a message. Call them later in the day to make sure you get through. Make sure also that you have that appointment for alcohol and drugs scheduled within the next 14 days. Make sure you follow all of its conditions. Sign any releases necessary for the evaluator and treatment provider to correspond with your probation officer.
Okay.
Mr. Aguirre, anything further?
Not on this matter, Judge.
Mr. Patterson, anything further?
Nothing further, Judge.
Mr. Paps, anything further?
No, ma'am.
Thank you. Then you are excused at this time, Mr. Paps. You may go. We will now be on the record in 2024 CR 388, State of Kansas versus Justin Lee Thorburn. County Attorney Jared Regier for the state, Attorney Darren Patterson for the defendant, Justin Lee Thorburn, who appears in person. Mr. Patterson.
Your Honor, after further discussions with Mr. Sweeney, there was an agreement that this case would be dismissed with prejudice because it was part of a previous global plea bargain on some felony cases that my client's currently on probation for.
And as a representative of the state, you support that and so move, Mr. Patterson? Or Mr. Regier?
One moment, Your Honor. I am in the process of confirming that, if the court will allow it.
Certainly. Go ahead, please.
Your Honor, based off of my notes, that would appear accurate. Unfortunately, I'm not in a position to advise the court as to which specific cases.
Very well. Mr. Thorburn, at this time, you are excused. The parties will journalize, if they have not already done so, your dismissal with prejudice. Thank you.
Thank you.
You're welcome. We will now be on the record in Tullis, BU 2023 TR 3074, State of Kansas versus Lucas Tullis. Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Mr. Patterson, announcements?
Thank you, Judge. I would announce this time Mr. Tullis is going to enter plea of guilty to the charge of driving after being declared a habitual violator.
Mr. Tullis, how do you plead to count one, driving after being declared an habitual violator? How do you plead? I'm sorry, sir, I didn't hear you. we're having a hard time. You're not putting out any sound.
He spoke to me earlier, Judge, so not for sure what's happened. There, say it again, Mr. Tullis, say this.
Can you hear me now?
Yes.
I plead guilty.
By pleading guilty, you're admitting that you did drive in Butler County, Kansas on July 30th of 2023 at a time while your driver's license was revoked due to habitual violator status?
Yes, ma'am.
And are you pleading guilty because you believe you were in fact guilty?
I am guilty, yeah.
And you understand you're giving up your right to trial, including the jury trial we have reserved for you with this plea?
Yes, ma'am, I do.
And do you understand that you'll be found guilty and won't be able to appeal that conviction?
Yes, I do.
And is anybody making you do this today?
No, Your Honor.
Did this happen as the officer's affidavit alleges out on Highway 54 outside of Augusta, approximately 7:40 a.m.?
Yeah, that is correct.
All right. I find that your plea is freely and knowingly given with a factual basis. Oh, and your license had been declared habitual, you said, right?
Yes, ma'am.
Prior thereto. All right, I find you guilty. Recommendations for sentencing, Mr. Regier.
Yes, Your Honor. The state's understanding is this is a case where the elevated sentence under KSA 287 applies. Therefore, pursuant to plea negotiations, the state is recommending the minimum fine required by law of $1,500. Also, pursuant to plea negotiations, the state is recommending court costs and a probation fee of $60 and for the court to make a determination on the issue of attorney's fees. The state is further recommending an underlying sentence of 1 year, subject to 1 year reporting probation. The state is not opposed to any orders the court may make as far as courtesy supervision is concerned, also pursuant to plea negotiations. The state's understanding is that pursuant to KSA 287, quote, the person convicted shall not be eligible for release on probation, suspension, or reduction of sentence or parole until the defendant has served at least 90 days imprisonment. The 90 days imprisonment mandated by this section may be served in a work release program only after such person has served 48 consecutive hours imprisonment, provided such work release program requires such person to return to the confinement at the end of the work release program. The state is prepared to recommend that the court follow the statute insofar as 48 consecutive hours and any other orders the court may deem appropriate insofar as the 90 days are concerned.
But we don't have a work release program here, do we?
Judge, the statute also allows house arrest program, and that is part of the agreement.
Does it actually allow it, or it's just silent on house arrest?
Your Honor, pursuant to at the very conclusion of KSA 287, it does appear to provide, quote, the court may place the person convicted under a house arrest program pursuant to KSA 216609 and amendments thereto, or any municipal ordinance to serve the remainder of the minimum sentence only after such person has served 48 consecutive hours imprisonment.
Okay. All right, at this time, Mr. Tullis, you live in what area, what town, city, state?
North of Emporia, Lyon County.
Lyon County, okay. Where do you work?
Simmons Pet Food.
And Your Honor, if the court wanted further information, I did send an email to court and counsel this morning with some additional documents. Those documents included a letter from his community corrections officer that outlines the things that he's currently involved in, which includes drug court, which includes that he is a part of the Corner House alumni group where he has already completed his drug and alcohol treatment completely. He is employed. My client also provided the drug court meeting criteria they go through, as well as some of his other meetings he has, and the breakdown of his monthly costs, which includes Butler and Associates taking $1,100 out of his paychecks, which is why he basically works a second job because of how much he's paying there, but those are additional documents for disposition in the case, Judge.
Very well. At this time, Mr. Tullis, you are fined $1,500 and ordered to serve a 1-year sentence. You also have attorney fees of $250, court costs of $108, and supervision fees of $60 because I am granting you a 1-year reporting probation after you've served 90 days. I don't want you to lose the job you have, so I will let you serve that 48 hours in jail, followed immediately by the remainder in house arrest, and only allowed to leave the house for work release. And to go directly to work and directly home. You're allowed to have courtesy supervision in your home county if that can be arranged. You are to pay 1/12 of the total due each month. On the 19th day of each month, your first 1/12 payment is due on June 19th of 2025. You are to start serving the 90 days within 1 week. When do you want to check in?
So it was my understanding that I was going to need to be put on house arrest before going into jail, or is that something that I can do upon immediate release if I had that set up?
What I'm envisioning is you serve the 48 hours, but before you go in, you contact the ankle monitor, electronic monitoring people so that they will show up when you get out of jail.
Okay.
And you'll go immediately onto that and immediately home.
Okay. Can we do that Monday? I guess that's Memorial Day.
And he's thinking of his days off from work, Your Honor. He's not a weekend person. He's a weekday is his off days. That's why he's asking for Monday.
You can begin that Monday, May, I believe that's the 26th. At what time are you checking in? 7 a.m.?
I'll be there. Yeah, 10 a.m. works great.
10 a.m. You must be there with the photo ID out there at 701 Stone Road. And like I said, call your EMD, electronic monitoring, and have them ready to show up when you get out.
I can do that. My only question is, so I am on felony corrections here in Lyon County, part of a drug court program. And I do have to go to court once a month. I have to go to an alumni group for drug and alcohol treatment once a month. And I have to attend 3 meetings a week. That's NA, church, AA.
I will authorize court appointments and treatment appointments.
Okay. Yeah, I just wanted to specify that. Okay.
Thank you for inquiring. Anything else?
I need to call probation right away, or?
Yes, call them right after court at 316 322 4153.
4153.
And Mr. Patterson, do you have the EMD number for him?
Yes. Write down this phone number also and call them after probation. 316-322-0021.
0021.
Correct.
Okay, I will call both of them right now.
All right, Mr. Patterson, anything further?
Nothing further.
Mr. Regier,
One moment, Your Honor.
while you're taking a moment, Deputy.
Judge, what was the charge on that?
His charge was driving after being declared habitual violator.
Okay, sounds good. Thank you.
Thank you.
Nothing further from the state, Your Honor.
All right, then we are in recess. Mr. Tullis is excused to call probation.
Thank you so much.
You're welcome. We'll now be on the record in Warren, case number BU 2024 TR 1832, State of Kansas versus Joel Patrick Warren II. Jared Regier for the state, Darren Patterson for the defendant, who also appears in person. Mr. Patterson.
Judge, pursuant to plea negotiations, I would announce at this time, Mr. Warren will be entering a plea of guilty to count 3, no proof of insurance. States agreed to dismiss 1 and 2.
Mr. Regier, that's your agreement?
That is the state's understanding, Your Honor.
Mr. Warren, that's your agreement?
Yes, ma'am.
How do you plead then to count 3, driving in Butler County, Kansas on July 8th of 2024 without liability insurance or proof of liability insurance?
Guilty.
By guilty, you're admitting that you did drive without insurance?
Yes, ma'am.
Is anyone making you enter this plea today by any threats or promises other than your plea agreement?
No, ma'am.
You understand that you will be found guilty having given up your right to trial, and you'll not be able to appeal your conviction with this plea.
Yes, ma'am.
And where were you driving in Butler County without insurance when the officer stopped you?
On the turnpike?
I-35, Kansas Turnpike.
Yes, ma'am.
And if the officer said you were doing so at mile marker 57 north in Butler County, you'd agree with that?
Yes, ma'am.
All right, I will accept your plea as knowingly and voluntarily made, find you guilty. Recommendations, counsel?
Yes, Your Honor. Pursuant to plea negotiations, the state is recommending the minimum fine required by law of $300, as well as the imposition of court costs. State is further recommending a 6-month non-reporting probationary period subject to an underlying sentence of 120 days.
Mr. Patterson?
I am retained in this case, Your Honor. Nothing further.
Okay. Mr. Warren, where do you work?
Dillon's in El Dorado.
Full time?
It's part-time right now, but I'm gonna be looking for some full-time employment.
And Judge, I'm retained in this case.
Oh, I thank you. All right, at this time, you are fined $300 and assessed court costs of $108. You're given a sentence of 120 days, but that is suspended so long as you successfully complete 6 months non-reporting probation. The non-reporting probation has 2 conditions. 1, do not violate any laws during the next 6 months. 2, pay the 408. Can you do that within 30 days?
Can I have 60 days?
You can have 60 days.
Okay.
Is that going to be enough?
Yes.
All right, I'm going to order that you pay the 408 within 60 days. As long as you pay within 60 and violate no laws, you'll be in compliance with your probation. Anything further, Mr. Regier?
Not on this matter, Judge.
Mr. Patterson?
Nothing further.
Then we all are in recess and Mr. Warren is excused. Oh, and for the record, the other counts are dismissed on motion of the state. Appropriately. Thank you. You may go, sir.
Thanks.
You're welcome. We'll now be on the record in 3 cases. BU 2024 CR 288, BU 2024 CR 291, BU 2024 CR 374, each captioned either State of Kansas versus James R. Young or State of Kansas versus James Richard Young. Jared Regier for the state, Darren Patterson for the defendant, who appears in person on all 3 counts or cases. Mr. Regier or Mr. Patterson?
Your Honor, these are announced for trial.
These are for trial. Can we consolidate these? Any reason we can't?
I apologize. I didn't understand the court.
Any reason why we couldn't consolidate these?
I would object to consolidation. Yes, Judge. I think the facts are pretty different from one another, as well as there's one that they have different victims, so that there's no motion on file to consolidate.
All right, well, court on its own motion brought it up. Okay, count in 24 CR 288, the defendant is alleged of violating a protection order. And that was alleged on June 16th of 24. With the no contact meeting with Elizabeth Goucher. Then in the 291, violation of a protection order, May 10th, the previous month, May 10th of 24. Does not say who the contact was with. Is it alleged to be Elizabeth Goucher also?
Yes, Judge.
'24 CR 374, domestic battery. And that allegedly occurred August 2nd of 24. After the two violations. With Patricia Williams. All right, I see where the Tricia Williams would be different. How about the two cases with the same victims, the two protective orders?
Judge, I am not prepared to take that up. It's not before me. I haven't received a motion for it. I haven't researched it. Right now, they're two separate cases, so I guess I object to it coming up right now.
All right, which of those three do you prefer to take up? They all happen within a couple months of each other.
James Young's phone died. He's running into the courthouse right now. James Young.
Okay, James Young's phone died. He's running into the courthouse right now. All right, we'll give him a minute.
I was right in the middle of my Zoom court, so I need to go down to the tab. My phone overheated.
And Judge, my client's relocating to the courthouse. She's having phone issues.
Noted.
Okay, Judge.
All right,
Sorry, Your Honor, my phone overheated right at that moment.
well, I'm just glad you're at the courthouse so we could proceed. We are continuing with the three cases concerning James Young. So the defense counsel has made it abundantly clear that they object to consolidation as the court had considered. The cases will not at this time be consolidated. So, Mr. Patterson, do you have a preference that you want to see them tried in, since they all allegedly happened within a few months of each other?
Judge, I would leave that to the state on which one they want to present.
Very well. Mr. Regier, does the state have a preference?
Your Honor, no preference per se. What I would tell the court is, I have not had the opportunity to speak to counsel for the defense regarding this case, so I'm not sure if the defense is even if the defense is even prepared to enter into plea negotiations. I just want to make that clear for purposes of the record. I'll of course defer to counsel for the defense on that point. There is one issue that I feel the court, and as an officer of the court, I do feel the court needs to be aware of. In 24 CR 291, it would appear that on July 19th, 2024, District Judge Satterfield did enter certain orders concerning bond in that case. I do have an affidavit from the jail that would appear to indicate that as of July 29th, 2024, the defendant failed to report to the Butler County Detention Facility as directed by the court to be processed and released. The state is not aware of any appearance bonds have ever been executed in the 24 CR 291 case, although there do appear to be appearance bonds in the other two cases, 24 CR 374 and 24 CR 288. So I will, of course, defer to the court as to how it wishes to proceed at this time regarding all three of these cases.
I'm going to order the council go into breakout room at this time and see if any agreement can be reached on these three matters. Jen, please put them in a breakout room. Mr. Regier and Mr. Patterson.
You do log out, go back in here. Good.
Your Honor,
Yes.
just, you're gonna, again, just put them in a breakout room, and that's when we're already set up for, we got first appearance starting in 5 minutes on that other computer.
All right. Well, whatever
I'll
we need
step
to
out.
do can happen. Well, they didn't want the defendant in there, just the attorneys.
Oh, you didn't want to defend.
Just the attorneys right now, Deputy.
Oh, never mind.
Okay, Jim, does that leave us with Jeremy Grimes and Crystal Haynes and Shoemaker?
I'm looking, Your Honor. It appears so for my paperwork.
Yeah. Is that what you're showing, Deputy Coppell? We have 3 possible trials left. Well, we have 1 failure to appear and 2 trials, Shoemaker and Grimes for trial.
Hold on, Judge. Everybody's talking in my hallway. I can't even hear you. Hold on.
Shoemaker.
Okay. The ones that I don't have anything on was Jennifer Grace.
She's not on here.
Not.
She's not on here
And
anymore.
Justin Thorburn.
We did him.
What did we do?
What we did was dismiss without prejudice per state.
Okay. John McGee. MAGEE.
What's the other name he goes by? Is he Thorburn?
Shoemaker.
You're Shoemaker, Mr. McGee? Okay. He's still waiting for determination. Anyone else besides Young?
I think that's it that I have.
Okay, and that, so. All right. So deputy, when they, what are we doing at 1:30? They're taking you or kicking us out of your room or both?
They're kicking us out of our breakout room.
Okay.
We got regular first appearance starting.
Okay, will you still be here or someone still be here in court security 1?
I'm gonna be here, yeah, for a little bit. I'm
Okay,
supposed to be doing the first appearance, but I'm gonna have John started over there, but I don't know what we're gonna do because there's a couple of people that need process, so we need a breakout room for that too, but I'll hang as long as I can.
okay, thank you. Hopefully we won't be much longer. Jen, on that John McGee, could you put Shoemaker on there? And John McGee, which one is your legal name?
I got both of them. It goes Shoemaker McGee.
Shoemaker hyphen McGee or just Shoemaker McGee?
Just Shoemaker space McGee, no hyphen or anything.
Okay. Thank you.
Hey, Al, I do need a breakout room.
With
How do you want
this
me to do it?
gentleman,
Yeah, how do you want me to do it?
just you and him could go in this one, I'll walk out.
Okay. Jen, can you put us in a breakout room?
Court 1.
Thank you, Judge.
You're welcome. We are back on the record in State versus Young, 24 CR 288, 24 CR 291, 24 CR 374, all parties as before. Counsel was afforded a breakout room, as was defendant and counsel. Are there any announcements, counsel?
Judge, it continues to be called for trial.
Well, thank you all for trying. Now then, that brings us back to determine which of these cases is going.
And Judge, we did on Crystal Haynes, we kind of put that to the end of the docket. We didn't complete it. I think we're ready to take that up.
Back on the record in 24 CR 485, State of Kansas versus Crystal Dawn Haynes. Jared Regier for the state, Darren Patterson for the defendant who fails to appear. This is our second calling for this 9 o'clock hearing. It is now 1:34 p.m. and near the end of the docket. Mr. Patterson, your client still does not appear. Any information on that?
Judge, we have made phone calls, but the phone number we had is not working at this point, so I have no way to contact her.
The court issues a bond forfeiture, a bench warrant, and a no bond hold due to failing to appear for pretrial.
Then Judge, on
yes.
Jeremy Grimes, again, that one's for plea, but we're wanting to see if it could be done today still by the state having contact with the victim.
Yes, Mr. Regier, we were told by the state that you needed to contact your victim before we proceeded. Have you made contact with the alleged victim?
Your Honor, I have been in this docket the whole morning. I will need a moment to confer with my colleagues if the court will allow it.
I will allow it, and I also would like for you to check to see if the alleged victim was given notice of this hearing and that pleas were possible. So you are excused to find that out. Thank you.
Thank you, Your Honor.
You're welcome. And in his absence, I'm going to take a brief recess. Anyone else that needs to may do so as well.